Make sure my phone's off. Good morning. Morning. Can y'all see and hear me okay? Yes, ma'am. Yes.
Judge Chavez, do you remember how to rename what the naming's supposed to be? I'm on my boss's account, so that's his name. I need to switch it. Is it judge at the end? Because you're the presiding judge, correct?
Yes, I think for this year I didn't see any specific requirements for scoring judges.
Okay, thank you. I couldn't remember the term either. I'm just going to put, I guess, scoring judge.
Yeah, I think that works. And your videos will be off during the trial, I believe, so you won't even appear on the screen. Okay. Because we're hiding all the non-video participants to try and make the recording a little bit more streamlined.
Okay, that sounds good. I'm going to try to get my coffee and get up for a second. So I'm going to get that all ready then. Thank you.
You're welcome.
Morning.
Good morning.
Morning, everybody. Hey.
Hi, Drew.
Hey. Good morning.
Good morning. It's so nice to see you.
How you doing?
I'm doing great. I hope you and your family are doing wonderful.
Yeah, they're great. They're great. Kids are getting big now. How are y'all?
Oh, I'm good. I'm really good. Or my husband and I are good.
Yeah.
So wait, have we decided how we're doing our names? Oh, that's right. They're not going to see us, so it doesn't matter. That's what you're saying. So
They
then
aren't. Yeah, in my presiding judge instructions, I don't have any instructions about how scoring judges are going to be named.
They're not going to see us, so it doesn't matter. They'll realize who we are when we pop up at the end.
It's a fine collection of ducks you have, Barbara.
So that was our wedding theme. Our anniversary is next week. And we got these last year on our 5-year wedding anniversary. So yes,
Nice.
home office. We're back at the office, but our computers don't have cameras, and then our Wi-Fi is not very great. We're updating it, so I have a good setup. I'm okay with it. But yeah, ducks. I was rearranging them. They're not all supposed to be here. I just kind of thought to make it pretty. I was traveling for work yesterday, so.
Like it.
Where are you out? Where are you, Drew?
I'm in Austin now. Yeah, I've been here about 3 years. So.
Nice.
Yeah.
That's awesome.
Yeah, we love it.
I have some really good friends out there.
I'm waiting on the 2 plaintiff students, but I have everybody else, all the judges. Yeah, so as soon as the 2 students we're waiting on enter the waiting room, I'll have you guys turn off your cameras and let them all in, and we'll get started.
Oh, we're supposed to turn our cameras off?
Yes.
Okay.
So I've got it set to where it'll hide non-video participants so that the screen is a little bit less cluttered for our live stream that we've got going on.
Got it. Thank you.
Of course.
Now I'm cleaning up my office area. Drew shamed me. I'm just joking. Dorky legal question. Does anybody have the new 2021 O'Connors yet? Ours hasn't come in yet, but I was just curious if maybe has it, if it explains anything good about the new rules or any good comments we should be looking at.
I don't have it yet.
I've got it online through West
Yeah.
Thomson Reuters, but I don't have the hard copy.
I like that hard copy. The person in charge at the office is getting them, but I was just curious. Someone else mentioned that you could look at it there, but just seeing if it had any interesting thoughts on it.
Well, most of the rule changes are not helpful to the trial practitioner.
Okay, I've got all of the students in the waiting room. So if y'all want to mute yourselves and turn off your videos, I'm going to let them in. Good morning, everyone.
Good morning.
Okay, so let's see. I'm just going to make sure I've got everyone checked in. Okay. And both of your second chairs are here just with their videos off, correct?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Perfect. Okay, well, we can give it 2 more minutes if you'd like, but if you're ready, we can get started. It's up to you.
Your Honor, if everybody's here and ready to go, the defense is ready.
Okay.
The plaintiff is also ready, Your Honor.
Okay, well then we will get started. The court is now calling to order cause number TGCV 00121, Jordan Gilmore versus Chimes Department Stores, Inc. Can I have an appearance on behalf of the plaintiff, please?
Yes, Your Honor. Good morning. My name is Jack Kasemsi. If you need me to spell that, let me know. It should be on the screen. And I'm joined here today with my co-counsel, Jared Koenig, and we represent Jordan Gilmore, the plaintiff in today's case.
Thank you. Can I have an appearance on behalf of the defense, please?
Good morning, Your Honor. My name is Rima Sahakian. I'm here with my co-counsel, Darshan Patel, and we represent the defendant, Chimes Department Co.
Wonderful. Do we have any housekeeping or pretrial matters to take care of before we begin openings?
Yes, Your Honor.
Yes, Your Honor. We have a few housekeeping matters.
Okay, why don't we take care of housekeeping first, and then if we have any pretrial motions, we can do that second.
Your Honor, the plaintiff was wondering what your preference was with screen sharing exhibits. How we have been doing it is that when we're entering in an exhibit, we ask the witness to pull it up themselves if they can see it. And then after laying the foundation and it's been admitted, then we publish it by screen sharing it.
I think that is a great plan to continue with.
Yes, Your Honor. May we assume that all objections are heard outside the presence of the jury?
Yes, you may.
And Your Honor, I'd just like to let you know that in our pretrial conference, we and the defense stipulated to the pre-admittance of a couple exhibits.
Okay, which exhibits?
Exhibit 2, 3, 5, 6, 10, 11, 22, 23, and 29.
Okay, I have note of all those exhibits and that they've been pre-admitted.
The plaintiff is ready to proceed, Your Honor.
Okay, any housekeeping matters from the defense?
Yes, Your Honor. A few housekeeping matters before we get into substantive motions. During the course of trial, counsel may ask to approach for a sidebar. May we do so constructively so that the other evaluators can hear our arguments?
Yes.
And Your Honor, the record contains a series of pre-marked exhibits, which may come in out of order. We ask that those exhibits retain those pre-marked numbers so that they can come in evidence outside of the order that's in the packet.
Okay, that is noted.
Your Honor, during meet and confer, we have also stipulated to a pretrial motion regarding the damages that will be discussed during this trial.
Okay.
Your Honor, both parties have agreed that there will be no mention of the number of stitches that the plaintiff received after getting treatment for the fall. There will be no introduction of exhibits 8 and 9, which are the photographs of the plaintiff's foot after the stitches were received. Your Honor, we've agreed that the mention of damages will be limited to the fact that the plaintiff fell, was injured, and then was diagnosed with an injury after the fact, as well as the fact that the plaintiff felt pain, Your Honor.
Okay, I have all of that down. Is there anything else that we need to take care of pre-trial?
No other housekeeping matters, Your Honor.
Okay. So do we have any pre-trial motions that we would like to address now?
Yes, Your Honor. The defense does have a couple of pre-trial motions.
Does the plaintiff have any?
No, Your Honor, we do not.
Okay. Defense, let's proceed with your pre-trial motions.
Your Honor, this is a case about a realty company that breached their contractual duty under a lease agreement to keep the loading dock at Chimes Department Store safe, as well as a plaintiff who chose to ignore common sense by climbing that landing dock too quickly. It was the combination of these two dangerous situations that caused the plaintiff to slip off the stairs and eventually get injured. Your Honor, our first motion is to exclude any mention of changes made to a light fixture by the loading dock after this accident occurred. So by way of background, after the accident, the owner of Chimes department store, Reese Geller, installed an additional light switch inside the Chimes department store. We move to exclude this evidence as evidence of a subsequent remedial measure under Federal Rule of Evidence 407.
Okay. Plaintiff, do you have any response?
Yes, Your Honor. We are going to offer this evidence to show that the defendant not only had knowledge that they were able to make this light turn on, but also that they had control over this light that was on the outside of the building. Furthermore, Your Honor, as you'll hear from the plaintiff today, they were informed that by the defendant that there was no way for the employees to be able to turn on this light. And therefore, we're using this to show that, in fact, the defendant did have control over this.
Okay. Chance, would you like a chance to respond?
Yes, Your Honor. With regard to control, the initial switch for this light was located in a different building, which would have required the defendant to actually have to go into the other store in the building to receive control. Now, we are open to stipulating to that limited purpose for the use of this evidence. We are not open to stipulating to any other issues through which this may come up, because that already treads on the line of using this evidence to show negligence rather than any of the acceptable exceptions.
Okay. At this time, I am going to deny your motion. Do you have any others that you would like to proceed with?
Yes, Your Honor. Your Honor, our final motion is to exclude any mention of a previous employee's injury at Chimes department store, as well as Exhibit 14, the recorded statement of that injury, as substantially more prejudicial than probative under Rule 403. Your Honor, evidence of this injury has low probative value because it occurred over 11 years before the injury at issue in this case occurred. We don't know if the conditions during that injury were one and the same as the one in this case. We don't know if the weather was the same. We don't know if it involved the same conduct. Further, Your Honor, the defense does not have the opportunity to cross-examine the individual who fell in this prior incident, and therefore this incident has trustworthiness in it as well. Thus, we move to exclude it under Rule 403.
Okay. Does the plaintiff have a response?
Yes, Your Honor. Part of our burden today in this trial is to show that the defense knew or should have known that that area where this incident occurred and where the plaintiff's incident also occurred, that it was a dangerous area, that there were unreasonable risks. The probative value of this report is extremely important to our case today. If you will let this be admitted, this exhibit will show that the defendant not only knew that there was someone else who was injured there, but the report will also show that that person who was injured let the defendant know, we need light back there and we need railings. And as you'll see today, even though the defendant took this report themselves, interviewed this employee, they did nothing to add lighting or railing. This is extremely probative in order for us to meet our burden to show that the defendant had knowledge of these unreasonable risks.
Your Honor, may I be heard?
Yes, you may.
Your Honor, we are not contesting that the defendant had knowledge of these issues. The issue in this case is whether the defendant actually had control over those railings and over those areas that required the changes in order to be able to make the changes. It's our theory of the case that the realty company that leased this property to the defendant was the only one that could actually make these changes. And therefore, Your Honor, this evidence should not be allowed to be used, as it is substantially more prejudicial than probative and was a wholly different event than the one that is in this case.
Sorry,
I
Your
have
Honor.
one quick question. Can you repeat again when this report was taken? How many years ago?
Yes, Your Honor. It was 11 years before the incident in this case occurred, more than a decade.
Your Honor, may I be heard?
Yes, briefly.
First of all, this incident actually occurred in 2010, whereas the incident we're here today occurred in 2019. So it was actually 9 years prior to this. Additionally, Your Honor, opposing counsel is mistaken. Our only thing here is not to show the defendant had control. We must show that there was an unreasonable risk, the defendant knew about this unreasonable risk, and that they failed to address this unreasonable risk that they knew about. And therefore, this is extremely probative to our burden.
Okay. At this time, I am going to deny this motion as well.
With that, Your Honor, the defense is ready for trial.
Okay. Is the plaintiff ready to proceed as well?
Yes, Your Honor. May I readjust this desk really quickly?
Yes, of course. And one quick housekeeping on my end, is there any time warnings that y'all would like me to give you at certain aspects, since you only have 55 minutes apiece?
Your Honor, we're fine with halfway through getting a time check from the co-counsels. And then if it's okay with you, I would just prefer that my co-counsel sends me time warnings during the closing.
Okay.
Likewise, Your Honor, that's fine with me as well.
Okay, wonderful. Well, then we will proceed. Plaintiff, you may begin with your opening statement.
May it please the court. Business first, safety last. That mentality, members of the jury, is what caused us to be here today. That mentality is what led to the plaintiff in today's case, Jordan Gilmore, to be forced by the defendant to go out on this makeshift loading dock that the defendant had created, putting Jordan Gilmore at risk and leading to his injury, her injury that brought us here today. This mindset of business first and safety last is what led the defendant to create a hazard when they turned an emergency exit into a makeshift loading dock. This mindset led the defendant to force their employees to go out those doors and on that makeshift loading dock every day. And this mindset led the defendant to choose not to do anything about this hazard that they had created. I want to take you back to the day that Jordan Gilmore was injured. January 23rd, 2019. Now, by this time, Jordan Gilmore had been working for Chimes Department Store, the defendant in today's case, for 10 years. Jordan had been a dedicated and devoted employee. Miss Gilmore was already forced to go onto that makeshift loading dock during her time there because the defendant chose to put their dumpster out there. They ordered this dumpster, they didn't tell their landlord about it, and then they put it out there and forced their employees to go out there. And 4 years prior to the night of the incident, the defendant made a rule. The defendant made a rule that if any of the employees wanted to take a quick smoke break during their shift, they had to go out back on to this loading dock with no safety measures. So on January 23rd, 2019, Jordan Gilmore was going to take a smoke break during her 8-hour shift that day. She and her friend Riley, who worked there too, went out together. They went out these doors that used to lead to an emergency exit and onto this loading dock. When they step out, there's no railing and there's no lights. There's no lights because the employees have learned that it is out of the defendant's control to turn that light on. There's no railing because the defendant took out that railing themselves. And so because there's no light, members of the jury, Jordan and her friend had to keep that door open in order so it wouldn't be pitch black. So Jordan and Riley, her coworker, step out there. Jordan goes down the steps in the dark, and as she's going down the steps, she has to hold on to the wall to keep her balance because there is no railing, even on the stairs. Jordan gets down to the bottom cautiously while Riley stays upstairs, and they talk for a little bit, take their break. And then when they're ready to go inside, Jordan cautiously goes up the stairs, holding on to that wall again for support. This night was a winter night. It was January 23rd, and as we know, Texas winters can not only be cold, they can be windy. And on this night it was. So as Jordan is going up the stairs, her friend Riley is holding open the door for her against the wind. Jordan has to let go of that wall for support when she gets to the top of the stairs because there's no railing around her. And as Jordan tries to step around her friend who's holding the door open for her, before she knows it, Jordan's foot slips and she falls backwards. Nothing to stop her from falling. Jordan tries to jump back in order to make sure that she lands on 2 feet, but the pavement underneath it was uneven. And because of that, Jordan landed on one of her knees a little harder than the other. And she immediately started to feel pain. I keep referring to this loading dock as a makeshift emergency exit, or this loading dock as a makeshift loading dock, because that's not what it was meant to be, members of the jury. And you're going to learn that today. We are here today to hold the defendant responsible for not making sure that their employees are safe. We are here today as the plaintiff to make sure that no longer can the defendant put business first and safety last. We're doing that today by bringing a claim to hold the defendant liable. And because of that, we have a burden of proof. We have to prove to you by a preponderance of the evidence that the defendant failed to use reasonable care. A preponderance of the evidence means more likely than not. Or if you want to think about it visually, you put all the evidence in favor of the defense on one side of the scale and all the evidence in favor of the plaintiff on the other side of the scale. And if those scales tip even slightly in the plaintiff's favor, then we've met our burden. And as you'll see today, members of the jury, we will have no problem tipping the scales much more than just slightly. In order to meet this burden, you're going to hear from a couple people today. We want you to hear from a couple people. First, you're going to hear from Jordan Gilmore, the plaintiff herself. And you're going to learn that Jordan Gilmore was just an employee trying to do her job. And unbeknown to her, her employers were putting her in danger, a danger that they created and failed to warn any of their employees about. You're also going to hear from Mr. Daines. Mr. Daines, who's a mechanical engineer, is going to explain how the defendant failed to keep their employees safe, how the defendant couldn't even give their employees a safe work environment. We're also going to talk with Reese Geller today. Reese Geller, who is the owner of the defendant Chimes department store. Now, when Reese takes the stand today, they're going to have to admit that they got that building and there was railing there. There was railing there because it was an emergency exit. And that the defendant asked, requested, wanted that railing to be taken out. And because they requested it, it got taken out. They're going to have to admit to you that even though they had the power to request to change that, they didn't request anything else. Reese Geller is going to have to admit to you that they did not try to put in any safety precautions on that makeshift loading dock. And when they chose not to put any safety precautions or ask for any, they then forced their employees to go out there day after day to take out the trash and to take their smoke breaks, because it's not classy to have employees smoking out front. Members of the jury, during today's case, I want you to watch the defense. And I want you to ask yourself, when you listen to the evidence today, what did the defendant do to make their work environment safe? What did the defendant do to make sure that employees like Jordan Gilmore, who had been working for them for 10 years, had a safe environment? And how did they force employees like Jordan Gilmore into a hazard? At the end of the trial, you're going to see that we're here today because the defendant put business first and safety last. And because of that, we're going to ask you to find the defendant liable.
The defense may proceed with their opening.
Yes, Your Honor. Members of the jury, what happened to Ms. Gilmore was unfortunate. And no one in this courtroom denies that, especially not Chimes department stores. Our hearts go out to Ms. Gilmore for the terrible injury that she suffered. But when accidents like this happen, we can't just focus on what happened. We have to ask ourselves why it happened. And today you'll learn that the why behind the what is clear. Because it was Kermit Realty Group who was in charge of maintaining that loading dock. And it was the plaintiff who knew the dock wasn't safe but made the decision to climb it in the dark anyways. Because hasty decisions can lead to harsh consequences. Now, before we talk more about the facts in this case, I'd like to tell you a little bit about the men and women of Chimes department store. People like Reese Geller. Miss Geller, will you please turn on your camera? Members of the jury, this is Reese Geller, the owner of Chimes department stores, or Chimes as most people like to call it. Chimes isn't a big or fancy store like Macy's. It's a smaller, lower end family owned business that Miss Geller has been with for her entire career. Even though her family owned the company, she worked hard to prove to them that they could trust her with the company when the time came. Thank you, Miss Geller. But as you just heard, the plaintiff is claiming that Chimes failed to maintain their loading dock in a safe manner, and that caused Miss Gilmore's injuries. But as Judge Chavez will tell you here in court, they can't just make claims, they have the burden to prove them. And if that scale that opposing counsel mentioned stays even, it doesn't tilt in their favor, then you have to find for the defendant. And today they'll fail to meet that burden because instead the evidence will show two things. First, that Chimes wasn't even the party responsible for keeping that loading dock safe. And second, that it was the plaintiff's own choices that led to her injury. So let's take a look at that first thing the evidence will show, that Chimes isn't the party responsible for maintaining that loading dock. And today, when Ms. Geller takes the stand, she'll tell you how she entered this lease with Kermit Realty Group. Now, the plaintiff just told you that it was Chimes' responsibility to make sure that loading dock followed all safety regulations. But Ms. Geller will explain to you that according to the terms of their lease agreement, Kermit Realty had the responsibility of making sure that dock was safe. They were the ones that had to maintain it, repair it, and inspect it, because they controlled what's called the common areas of that shopping center. And you'll hear that the term common areas includes the area where Miss Gilmore fell below the loading dock. And as the landlord, Kermit Realty was supposed to make sure that anyone who made use of that loading dock was safe. And you're also going to hear from an Occupational Hazard and Safety Administration Officer, or OSHA for short, Perry Hayden, whose job it is to inspect workplaces to make sure that they comply with government safety guidelines. You'll hear that according to Mr. Hayden, loading docks aren't covered by any of the regulations that OSHA has. In fact, you'll hear that Perry Hayden went to Chimes department store in 2018 before this accident even occurred for a regularly scheduled inspection like OSHA normally does. And you'll learn Mr. Hayden didn't find any violations of OSHA standards, especially the ones that related to having loading dock guardrails. And that's because if OSHA wanted those loading docks to be free from anything that interfered with them, you would have seen that. They tried to prevent the docks from being used in a way that would prevent shop owners from getting their supplies. And so that brings me to the second thing the evidence will show, that it was the plaintiff's own choices that led to her injury. But to understand that, we have to go back to the day of the accident. Opposing counsel talked about mindset a lot. So let's talk about Miss Gilmore's mindset that day. She's about an hour away from finishing an 8-hour shift when she decides it's time to take a smoke break with her coworker. And as they walk outside, she recognizes that it's dark outside because the sun has already set and the light on the dock was turned off. But that wasn't the first time that this light had been turned off. In fact, the plaintiff will admit it was a regular occurrence. And as someone who had been working for Chimes for over 10 years, the plaintiff knew that. But despite knowing that the light was off, despite knowing that there was no railing on the stairs, despite knowing that the door that her coworker opened blocked her path, the defendant still walked all the way down to the loading block and then tried to quickly climb back up, a decision that ultimately led her to fall, causing her injuries. Hasty decisions can lead to harsh consequences. And that's just not Chimes' fault. That's why at the end of this trial, I'll ask you to find the only just verdict, the only fair verdict, a verdict finding the defendant not liable.
Okay, Miss Casensi, did I say that correctly?
You did. Wow.
Okay.
I'm impressed.
Are you ready to proceed with your first witness?
Yes, Your Honor. The plaintiff calls Jordan Gilmore to the stand.
Ms. Gilmore, I just remind you that you have been previously sworn in under oath.
Good morning, Ms. Gilmore. Introduce yourself to the jury.
Hi, my name is Jordan Gilmore.
Ms. Gilmore, where do you live?
I live here in Waco, Texas.
Are you involved in the community at Waco?
Yeah, I participate in church. I go to Sunday school. I have a lot of friends through Sunday school. We actually have a book club, and I hang out with my friends playing cards and just kind of running around town some.
Since you live here in Waco, where do you work?
Right now, I'm not working actually, but before I was unemployed, I worked at Chimes.
How long did you work at Chimes department store?
I was roughly about 10 years.
I want to talk about your fall that resulted in your injury in 2019.
Okay.
Where were you working at that time?
I was working at Chimes at that time.
What was your job at Chimes department store?
I was the cashier, so I was up at the front checking people out and kind of greeting them.
Was this injury while you were working?
It was while I was clocked in. I had gone to take a smoke break while I was working.
You said that you'd gone to take a smoke break. Where on the location did you take a smoke break?
So it was actually at the back of the store. You went out, I think it used to be maybe like an emergency exit, but it's where our loading dock is now. So I went back in the back of it.
Miss Gilmore, could you find Exhibit 2 in your case packet for me? And just let me know when you found it.
Sure, I have it.
Miss Gilmore, what is this a picture of?
This is a picture of the loading dock that I was just talking about that I walked down for my smoke break that day.
And does this picture accurately show the loading dock at Chimes department store?
Yes, it does.
Your Honor, at this time, we would like to remind the judge that it's been pre-admitted into evidence.
Yes.
Co-counsel, if you could please share the exhibit. Can you see that, Miss Gilmore?
Yes, I can.
Okay, could you just explain to the jury what this is a picture of?
Yes. So the door that has the number 1009 is the door that I would walk out of onto that loading dock. And then I would turn and go down those stairs to go over by the dumpster to have my smoke break.
And Miss Gilmore, when you took your smoke breaks, you had to go out those doors every day?
Yes, for my smoke breaks to take trash out to that dumpster that you see right there. So I was out there a few times a day.
Would you recognize a picture of the inside of those doors if I showed it to you?
I would think so, yeah.
Opposing counsel, could you please pull up Exhibit 6 for us? Or not opposing counsel, co-counsel, excuse me. Jared, Mr. Koenig, could you pull up Exhibit 6? Thank you. Can you see this, Miss Gilmore?
Yes, I can.
Explain to the jury what it is that we're all looking at right now.
So this is the same loading dock that was on the picture we were just talking about. But this one shows the doors when they're both completely propped open.
Now, I'm going to have a circle around part of this picture drawn for you. Could you please explain what that red circle is around?
Yeah, it's a sign that says, "Do not block, fire exit."
And have you seen this sign before?
Yeah, every single time I walk through those doors.
I'm going to circle another part of this picture for you. Do you see that black circle?
Yes.
What does that show in this picture, Miss Gilmore?
So that's obviously like the corner of the loading dock, but it's chipped. There's kind of rods or wires, I'm not really sure what you would call it, sticking out of it. And it's just showing how deteriorated that loading dock has kind of become over time.
Thank you, Miss Gilmore. You could take that down, Mr. Koenig. So, Miss Gilmore, I just want to establish something. You keep referring to this stairwell area as a loading dock. When you started working at Chimes, were you informed by them that this used to be an emergency exit?
I don't think I was ever informed explicitly, but I mean, the sign kind of gave it away.
Were you ever told that there used to be railing around this emergency exit?
There was never railing whenever I was there. It was a loading dock, so I'm not really sure how you would even have railings on it, but I don't think I was ever explicitly told that in my time there.
So were you ever informed that railing that had been there before was removed by Chimes department store?
I honestly don't recall.
Now, Ms. Gilmore, we've talked about how you went out there for smoke breaks a lot. When you went out those doors with that sign on it, did an alarm ever go off?
No.
I want to move on so that we can really talk about what happened on the night that you were injured, January 23rd, 2019. You told us that you were a cashier at Chimes. Why exactly were you then on the loading dock that night?
Well, like I said, that's where we were having to go take our smoke breaks if we took a smoke break. And also that's where the dumpster was. So there were times where we were required to throw things away. So we would also go back there for that. But that particular night I was taking a smoke break.
Were you sent an email by your employer about the smoke breaks needing to be back there?
Yes, I was a few years prior to my injury.
Ms. Gilmore, could you find Exhibit 1 for me and just let me know when you have it?
Sure. Okay, I have it.
Explain to the jury what you're looking at.
So this is a memo that we were sent by Lane Kim, who's the manager. She sent this out to all employees saying that the owner of Chimes doesn't want any employees, including myself, obviously, taking smoke breaks in the front of the store, and that for all smoke breaks, we're required to go out the back door off that loading dock like we just looked at. It also talks about like picking up trash and that kind of stuff back there as well.
Has this been altered since you last saw it?
No, it has not.
Your Honor, the plaintiff moves to enter Exhibit 1 into evidence.
Any objections from the defense?
No objection, Your Honor.
With that, I admit Exhibit number 1.
Mr. Koenig, could you please screen share this in order to publish it to the jury? So, Ms. Gilmore, just really quickly while we're looking at this, could you summarize what this email said from your manager?
Yes, it says that Reese had come by the store and someone was smoking out front. So it was an additional reminder and making sure that all the employees were aware that all smoke breaks had to be taken in the back of the store where the dumpster is, and that we weren't allowed to smoke in the front of the store at all. And then again, to pick up any trash that you see by the dumpster.
This email talks about going and smoking by the dumpster. What doors did you have to go out in order to go take your smoke breaks by the dumpster?
It would be those loading dock doors that we looked at earlier that kind of prop open in an L-shaped form.
And just so we can clarify for the jury, Ms. Gilmore, can you tell us who Reese is that's mentioned in this?
Reese is the owner of Chimes.
Thank you, Ms. Gilmore. You can take that down, Mr. Koenig. So let's get back to when you went out there on January 23rd, 2019. Did you go out there with anyone?
Yes, I went out there with my friend, Miss Hunsberger, Riley Hunsberger.
Tell us about what time of day it was when you went out there.
When I went out there, it was nighttime. I mean, it was winter, so it got dark really early, but it was about 7 p.m., I think.
So when you and Riley went out those doors, what was the lighting like out there?
It was pitch black. There's no lighting out there. So other than what little light was coming from the door inside, there was no other light.
Was there a light near the makeshift loading dock, Miss Gilmore?
There was a light, but not one that was on.
Were you able to turn this light on?
No.
Were you ever informed by one of your employers if you were able to turn this light on?
We were told that we couldn't turn that light on because the switch for that light was next door in the Tractor Supply building. And so we were told that we didn't have access to it. And so there was basically nothing that they could do to provide any light out there for us.
So you and Riley go out these doors. It's pitch black. What did you do next?
Well, I turned to go down the stairs, which were on my right. And I usually kind of steadied myself on the wall going down them, walked down the stairs, and then walked over towards the dumpster to take my smoke break.
So I just want to clarify something that you just said, Miss Gilmore. You said that you have to hold on to the wall while going down those stairs. Why is that?
I usually did just because it was really windy usually, and that night was especially windy. And so I just steadied myself a little bit walking down the stairs.
Was there anything for you to hold on to while going down these stairs in the dark?
Not other than the building wall that it was attached to. There wasn't a railing or anything.
Where was Riley standing when you guys went out there?
Riley actually stayed up at the top of it. It was really cold, so I think Riley was trying to get a little bit of a wind block, but I just kind of stuck with my habit and went down to the dumpster because I didn't like my smoke blowing back into the store.
I understand. So after you're done taking your break, explain to us what happened next.
So I was done taking my break, and then I went back and kind of reversed my actions to go back up and was walking up the steps to the loading dock, and Riley had the door open. And so there was a little bit of a walkway on the other side, like a little bit of a space. And so I tried to go that direction, but that was when I fell off the top of that loading dock.
Miss Gilmore, I'd like to pull up Exhibit 5, which has been pre-admitted, and have you take a look at it.
Okay, I've got it.
And if Mr. Koenig, you could pull up Exhibit 5 for us. Thank you. So, Ms. Gilmore, explain to the jury what we're looking at right now.
So this is I guess, kind of makeshift diagram of what that loading dock would look like from an aerial view.
And did you make this diagram?
No.
When were you shown this diagram?
I believe the first time I saw it was at my deposition.
And is this an accurate depiction of the placement of the landing and door and steps when you were going up that landing?
Yes, I'm not sure of the scale of it or anything like that, but it's a pretty accurate depiction.
I want to now show you Exhibit 3, which has been pre-admitted.
Okay.
Ms. Gilmore, tell us about what we're looking at right now.
So this is kind of a downward angle of that door when it's open to the right that I would have to go basically by to get to the stairs to go down off the loading dock. So
when you were telling us about how you had to go around that door, is this an accurate depiction at how much space there was for you to go around?
Yes, it's an accurate depiction. It was a really small space, as you can see.
Thank you, Ms. Gilmore. So for the jury, would you just kind of break down what exactly happened when you fell down that?
Objection, Your Honor, vague.
Can you rephrase the question, Ms. Kasemsi?
Yes, Your Honor. Ms. Gilmore, could you explain your falling from that platform and what happened?
Yeah, so like I said, the door was open like it was in that last picture you just showed me. Riley was still holding it. It was swung out, so it was kind of blocking my path. So there was a very narrow walkway. And so I had to kind of go around it. And as I was stepping onto the landing, my foot just, I guess, slipped out from under me. And I fell down and tried to jump and land on both feet, but it was all uneven. So I mostly landed on one of my legs, my right leg specifically, and then fell backwards and eventually landing on my butt.
Did you feel any pain at that moment?
Yeah, I felt pain at that moment.
Where did you feel pain?
In my knee.
Ms. Gilmore, were you interviewed by your employer about this incident where you fell off their loading dock?
Yes, I was.
Would you recognize the document that was made for that interview if I showed it to you?
Yeah, I think so.
Mr. Koenig, if you could pull up what has been pre-admitted as Exhibit 10. Ms. Gilmore, explain to the jury what we're looking at here.
So this is the statement that I gave to Lane Kim, my supervisor. I think it was like a couple days after my incident, but just going over what happened that night.
And I want to go to the second page of this. Ms. Gilmore, can you explain what you answered to the question, was the accident caused by faulty or malfunctioning equipment?
Yes. So my answer to that was, if the lights would have been on or if the steps had guardrails, then I probably wouldn't have fallen off the landing dock.
Objection, Your Honor, lacks foundation and speculation. May we approach?
Yes, you may.
Your Honor, this witness has no background or expertise to be able to say as to what would have changed or what would have made a difference to break her fall. And therefore, this is speculation and lacks foundation.
May I respond, Your Honor?
Yes, Ms. Kasemsi.
Opposing counsel had already agreed to this entire exhibit being pre-admitted in pre-trial. So all we're doing right now is highlighting parts of it that are admitted into evidence.
Your Honor, may I be heard?
Yes, Ms. Sahakian, is that correct?
Yes, that's perfect, Your Honor. While the exhibit is in evidence to ask the witness to opine as to what she thinks would have made the difference, is going outside of the scope of her personal knowledge in this case. She is a lay witness, and therefore she cannot speculate as to what she thought would have made the difference.
Your objection is sustained.
And motion to strike if there was an answer?
Granted.
Ms. Gilmore, I'm going to take you to the third page of this report.
Okay.
Did you answer these last couple questions?
No, I stopped answering the questions where you can see my signature. So everything above that I answered, but everything below that was not my answers.
According to this, can you see who made these answers from this paper?
It says it has to be filled out by the supervisor or manager, so I would assume Lane Kim.
Thank you. We can take down that exhibit now. Now, Ms. Gilmore, I'm going to ask you one last question. We're here today because you were injured. How did you discover that you had sustained an injury from that fall?
Well, like I said, I felt pain whenever I initially landed. But the day after that, I went to the ER and saw an orthopedic specialist who eventually diagnosed my injury.
No further questions, Your Honor. I pass the witness.
Okay.
Cross-examination, Your Honor.
You may proceed.
Ms. Gilmore, on the night of your accident, you weren't a new employee at Chime's department store, right?
Right.
You had been working there for 10 years.
Yeah, give or take a little bit, yes.
And those 10 years you had spent at the same location.
Yes.
And During those 10 years, you always took smoking breaks,
Yeah.
at least one a day.
Yeah, usually.
And you took those breaks in the back of the store by the loading dock.
Yes, that was the protocol they gave us.
You also went to the loading dock to throw out trash in the dumpster, right?
Yeah.
You do that once or twice a day.
Yeah, it kind of varied by day, but that's fair.
And so you'd estimate that you were out on the loading dock about 20 times a week.
Yeah, I would say so.
In your own words, you were pretty familiar with the area.
Yeah, you get there after about 10 years.
But on the night of your accident, you had been working all day.
Yeah.
You had been working since noon.
Yeah, I mean, it was a normal 8-hour shift.
And you weren't getting off until the store closed at 8 o'clock.
Right.
By 7 p.m., you needed that smoking break, right?
Yeah.
You knew it was cold outside.
Yeah, that's why I tried to go out there for a really short amount of time.
You knew that it was windy.
Yes.
So, like you just said, you didn't plan on being out there for very long.
Right.
You even knew that the light outside, it was going to be off.
Yeah, it was off all 10 years that I worked there. So,
in fact, you can't recall a single time that the light was ever on.
Right.
But despite that, you didn't choose to go smoke in your car.
No, it was protocol for us to go out in the back.
Well, even though you had smoked in your car during your lunch breaks before, right?
Yeah, I mean, it just made sense if I was leaving the business to smoke in my car while I was leaving work to go get lunch.
Well, you also knew that there wasn't any railing to hold on to while you were out there, right?
Right.
And that's because there hadn't been a railing for as long as you had been working there.
Right.
Now, you never complained about the lack of a railing, right?
I mean, it didn't really make sense to me why there could be a railing because it was a loading dock, but I mean, after that night, it would have been nice for there to have been a railing. I wouldn't have fallen, like I said.
Well, bringing you back to my question, you never complained about the lack of a railing.
No, I don't think so.
Because like you just said, it wouldn't make sense to have a railing on a loading dock.
Right.
Now, you mentioned on direct examination something about a fire exit, right?
Yes, there was a sign that said emergency exit, I believe.
That's right. You testified that that door that you came out of was a fire exit. I got that right.
I believe it used to be. Like I said, now it's a loading dock.
Well, this is the first time that you're ever telling us that that door used to be a fire exit, right?
I guess I'm not really sure who all I've talked to about it being a fire exit before this.
You never mentioned it in your prior deposition.
No, I don't believe so.
This is the first time we're hearing about it in front of a jury.
Yes, I don't think I was ever asked about the sign on the door before this.
Now, the night that you walked down the stairs to go smoke, you walked all the way to the bottom of the loading dock, right?
Right.
You'd never had any problems getting down those steps before.
No, I mean, it was always dark, but I had never fallen.
And then you went to go get back up the stairs.
Yes.
You never had a problem with getting back up those stairs either.
No, like I said, this was the first time I've fallen off the loading dock.
But on this night, your coworker Riley went to smoke with you.
Yes.
But instead of coming downstairs to smoke, she stayed in the doorway, right?
Right.
And she blocked some of the light that came through the door.
Yeah, but if the door wouldn't have been propped open with her holding it, there also would have been no light out there.
Well, you didn't ask Riley to move so the door could be open fully, right?
Right. Like I said, if she wouldn't have been standing there, there would have been no light.
Well, you're aware that there was a second door next to her.
Yes.
You didn't open the second door to let out more light either.
No.
You didn't bring a cell phone with you to use as a flashlight.
No.
You didn't ask Riley to use her cell phone as a flashlight either.
No.
Instead, you claim that on that night, you had to put your hand on the wall to steady yourself.
Yeah, I mean, I usually did that just because, again, there was no railing. So it was the only thing to guide you down the stairs.
In your deposition, you say you did that multiple times, right?
I believe so, yes.
But you gave a statement to your employer about the accident.
Yes.
And we saw that statement on direct examination. That's Exhibit 10, right?
Yes.
Mr. Patel, will you please post Exhibit 10 for the jury? Your Honor, this has already been entered into evidence. Thank you. Ms. Gilmore, are you able to see that?
Yes, I can.
Now, at the bottom of the first page, you describe in detail how the accident happened.
Yes.
Nowhere in that description do you mention using your hand to steady yourself, right?
I don't believe so from what's written here, no.
And that statement, that was given just 2 days after the accident.
Right.
The first time you mentioned your hand on the wall was June of 2020 when you had your deposition taken for this lawsuit you filed.
I'm not sure of the exact date, but yes, I guess, agree with you.
And that was almost a year and a half after the accident.
Okay.
Is that a yes?
Yes.
No further questions, Your Honor.
Any redirect, Ms. Kasumsi?
Yes, Your Honor. Ms. Gilmore, you were asked a lot about how many times you went out those doors onto the makeshift loading dock. Can you just explain to the jury why you went out there 20 times a week?
Yeah, I mean, like the memo you showed me earlier, it was protocol set by the store I worked at to take our smoke breaks in the back. That was also, as we've seen, where the dumpster was, that I had to take trash out multiple times a day. So it was just kind of in my regular job to go out there if I had to take trash out or if I ever wanted a break like that.
And just to clarify for the jury, were you shown Exhibit 6 during your deposition of those doors?
No, like I said, I was never asked about the emergency sign on the door during my deposition.
But did you go out those doors with that sign on there every time you went out them?
Yes.
No further questions, Your Honor.
Any recross, Ms. Sagan?
No recross, Your Honor.
Okay. If there's no further questions, can this witness be excused?
Yes, Your Honor.
Ms. Gilmore, you are excused. Ms. Kasumsi, do you have another witness to call?
Your Honor, at this time, pursuant to the pretrial order, we would like to read in some of the lines from the deposition of Mr. Daines.
Okay.
Mr. Koenig, are you ready?
Yes.
Starting on page 2, line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Daines.
Moving on to line 10 on that same page. Where do you live?
I live with my family in Madison, Wisconsin.
Tell us about your education.
I have a Bachelor's of Science in Mechanical Engineering from the University of Wisconsin-Madison.
Moving on to line 24 on that same page. I noticed that your CV lists you as a PE. What is that?
It stands for Professional Engineer.
What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the Fundamentals of Engineering exam, which I did. Then you work as an engineer for 4 years before you take the Professional Engineering exam. So I took that as well, and I passed.
What do you do professionally?
I am the president of Daines Engineering, LLC.
What does your company do?
We provide forensic investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Moving on to page 4, starting at line 14. Over the course of your career, how many incidents have you investigated?
Over 60.
Moving on. to page 5. We're going to start at line 14. All right, Kelly, I want you to move on and talk about your work in this case. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Your Honor, at this time, the plaintiff would like to tender Kelly Danes as an expert in mechanical engineering with a specialization in industrial, commercial, and business engineering.
Okay. I believe that according to our pretrial order, we are not having any objections to the qualifications of experts. So Mr. Danes is thus designated.
Moving on to page 7. Starting at line 1, I'm showing you what has been marked as exhibits 22 through 30. Do you recognize these?
Yes, these are pictures of other areas out behind that strip center.
Are exhibits 22 through 30 fair and accurate depictions of how those areas appeared at the time of your inspection?
Yes.
Your Honor, at this time, we would like to constructively publish to the jury exhibit 22, 23, and 29, which have been pre-admitted.
You may do so.
On that same page, moving to line 8, what do these pictures show?
Well, there are multiple stores in that little strip center, and they all have some kind of landing area and steps behind them, just like Chimes. However, as you can see from these photographs, nobody else has removed the railings from these areas. So what you see in these photographs is what the landing area behind Chimes would have looked like with railings and what it should have looked like in order to be safe.
Moving on to page 9, starting on line 9. All right, so which portions of the IBC codes and the OSHA regulations did you find?
I'm sorry to interrupt you. Our jury is having a bit of a hard time hearing Mr. Koenig, if he would mind speaking up when he's answering his questions.
Mr. Koenig, would you just say some words to see if the jury can hear you?
Testing. 1, 2, 3.
I think that's better. Thank you, Mr. Koenig.
Picking up at line 14 on page 9, why are those significant in this case?
These are general provisions that require an employer and or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here you can see from the photographs I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of light switch to turn on the light above these stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified those standards. So fairly clearly, the defendant violated these requirements under both the IBC and OSHA regulations.
No further questions, Your Honor.
Any questions from the defense?
Yes, Your Honor. May my co-counsel turn on his camera so that we could read the deposition?
Yes, you may.
And Your Honor, just to let the court know, I'm going to be looking at my second monitor so that the court is aware that that's the reason why I'm looking off in the distance.
Thank you.
Okay, starting on page 3, line 22, question. Based on what you do for a living, is it fair to assume that you regularly testify in lawsuits?
Answer, yes, no question about it. I testify and work as an expert on cases on a regular basis. To be honest, preparing expert opinions in lawsuits like this one, testifying in depositions, and testifying at trials are about 99% of what I do at this point.
Moving on to line 11 on page 4, question. Have you ever worked in code enforcement at any level of the government?
No, I've always been in private practice.
Line 21 on page 4, question. How did you get involved in this case?
I got a call from the firm representing the plaintiff, Jordan Gilmore. It's a firm I've done work for in the past, so this isn't the first time I've consulted in one of their cases.
Page 5, line 3, question. Kelly, I'm showing you what has been marked as Exhibit 15. Do you recognize this?
Yes, it is the invoice for the work that I've done so far in the case, which obviously doesn't include my time today or my time for testifying at trial if I have to do that.
Page 9, line 4. Question. Do you know or have any opinion on who was responsible for the maintenance and repair of these steps behind the Chime store?
No, that's not what I was asked to do. I assume it was Chimes, but that's just a guess.
Page 10, line 19. Do the OSHA regulations place any requirements on employees?
Yes, there is a general duty requirement in 29 USCS section 654B, which says that employees also have to comply with the OSHA standards and regulations and basically have to be responsible for their own actions.
Page 11, line 20. Question. Have you ever seen that light above those stairs turned on at night? Do you know how much light it would have provided?
No, I've never seen that.
Page 14, line 12. Question. You would agree, though, that this area was used by Chimes as a loading dock at times?
Yes, at times.
Question. And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock?
Yes, it would make it difficult.
Question. Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
Your Honor, that concludes our reading of this witness's deposition.
Thank you. Any redirect, Ms. Kasemsi?
No, Your Honor. May the witness be excused.
Yes, this witness may be excused. Do you have any further witnesses to call?
No, Your Honor, but before we rest our case in chief, we would like to make a motion. We would like to conditionally move Exhibit 4 into evidence, which is the incident report that was mentioned earlier in pretrial. Your Honor, this exhibit is mentioned in the deposition of the defendant. Now, due to the pretrial order, we as the plaintiff aren't able to call the defendant to the stand. And therefore, we would like to conditionally move it into evidence now so that we may question the defendant when they are able to take the stand about this exhibit.
Any objections from the defense?
Your Honor, I just request a clarification on Exhibit 4 is a photo of the door at the landing dock. I don't know if opposing counsel is referring to a different exhibit.
I meant Exhibit 14, excuse me, Your Honor.
Okay.
Your Honor, this is the exhibit that entails the previous instance of somebody falling at the loading dock, and therefore we would re-raise our same objections under Rule 403.
Can you pull up Exhibit 14 for me to take a look at?
Absolutely, Your Honor. Would you like me to screen share it for you?
Yes, please.
Give me one moment.
Your Honor, may I respond as we're looking at this to counsel just re-raising her objection? So, Your Honor, as you'll see, this is an identical worksheet that this business uses, and we've already pre-admitted Exhibit 10 into evidence. So it's already been validated that this is an authentic document that business uses to investigate injuries that happen and incidents with its employees. Once again, Your Honor, I would like to remind the court that we have a burden of proving that the defendant knew that there were unreasonable risks that they created, and also to show that they did nothing to address those. This recorded statement literally shows an incident that happened on that same loading dock. And in this recorded statement, the manager themselves suggests that they could have made some changes. And therefore, this goes towards knowledge and it's extremely probative to our case.
Your Honor, may I be heard?
Yes.
Your Honor, authenticity is not in dispute with this exhibit. What is in dispute is the fact that it is substantially more prejudicial than probative because this was an isolated incident that occurred in 2010, which was years before the incident in this case occurred. And based on opposing counsel's argument, Your Honor, I would also add that opposing counsel is showing this document to show action and conformity therewith under Rule 404. That just because one time there was an incident, now there's another time that is in conformity with that same incident, and therefore they're using it as improper character evidence as well.
Your Honor, may I respond to the improper character evidence?
Yes, briefly.
We are mainly going to use this to show knowledge. It's extremely important that we show that the defendant was notified that there were unreasonable risks back there.
Ms. Sawkin, would your objection continue if this was admitted for the limited use of showing knowledge that the light in that area had been previously out in another incident?
Yes, Your Honor, that still does not solve the issue under Rule 403. The problem that there is with the fact that we cannot interview any of the individuals who are involved in this. We don't have the manager who took this interview. We don't have the individual who actually was injured. And therefore, we can't even be sure that it involved the same issues that are at dispute in this case. And therefore, to just use this document isolated by itself is substantially more prejudicial than probative and will mislead the members of the jury into believing that the defendant is negligent in this case.
Okay. At this time, I'm going to deny the admittance of exhibit number 14 into evidence.
Your Honor, may be heard very briefly.
Yes.
If we would be willing to constructively strike all of this except for the date of the incident and the last part, which are statements made by the opposing party, the manager, would opposing counsel be willing for us to admit it with everything else, the narrative and all that, constructively stricken, except for the date and the last part, which is a opposing party statement, which shows knowledge?
Your Honor, may I be heard?
Yes.
This goes back to the initial concern with character evidence. Redacting those statements and then having just the date is trying to show action and conformity therewith.
My ruling stands. This is not going to be admitted into evidence. If you have anything further, Ms. Kasensi?
Yes, Your Honor, just briefly. We would also conditionally move that Exhibit 13 be entered into evidence right now. Once again, this is an exhibit mentioned in the deposition of the defendant. We weren't able to call them. And Exhibit 13 is a statement made directly by the opposing party.
Any objections, Ms. Hawken, to Exhibit 13?
Your Honor, this is a letter that was written by the defendant to the landlord in this case. We ask that this letter is shown to the defendant and therefore for the defendant to show personal knowledge and to lay foundation. Your Honor, to clarify, the drafter of this email is actually the defendant's father, who works in the same business, but I just ask that there is foundation laid so that the defendant, who is the daughter, can testify to it.
Your Honor, may I just clarify something very quickly?
Yes.
The defendant in today's case isn't Reese Geller. The defendant is Chimes Department Store, and this was sent by the defendant, Chimes Department Store.
Can you please put Exhibit 13 up on the screen for me?
I have it, Your Honor. I can share it.
Thank you.
As you can see from the bottom of this email, Your Honor, it is signed Chimes Department Store. So it was sent from the opposing party, the defendant.
At this time, I am going to admit Exhibit 13 into evidence as a statement by a party opponent.
Yes, Your Honor. At this time, the plaintiff rests their case with permission to be able to recall any witness if we wish to at the end.
Yes. Ms. Hawken, are you ready to proceed with your case in chief?
Yes, Your Honor. We just ask for a brief 5-minute break before proceeding to the defense case in chief. If Your Honor doesn't want a break, we don't have to. I was just wondering maybe for the members of the jury as well.
Let me ask our jury members if they need a break. If not, I think we should continue through just to make sure we're staying on time.
No
So jury members, if you'd let me know in the chat if any one of you needs a quick break or if we can continue. Okay, I think our jury is fine, so why don't we go ahead and proceed?
Your Honor, defense calls Reese Geller to the stand.
Ms. Geller, you're reminded that you have been previously sworn in and that you are under oath.
Yes, Your Honor.
Ms. Geller, can you hear me okay?
Yes, I can.
Perfect. Now, good morning. Please introduce yourself to the jury and tell us where you live.
Good morning. My name is Reese Geller, and I live in Waco, Texas.
Are you married?
I am. I am married to my wife, Peyton, or husband, Peyton.
Tell us about your educational background.
I graduated from Baylor in 1998 with a bachelor's degree in business.
What do you do for a living?
I'm the owner of Chimes.
What's Chimes?
It's a department store, kind of like Macy's or JCPenney's, but a little bit smaller, not as big as a typical Macy's that you would see.
Well, have you always been the owner of Chimes?
I have not. It's a family business, and I started from the bottom, working and buying, and had to slowly work my way up until I became the boss.
How long have you worked at Chimes?
Since I graduated from college, it was started in the buying department right after I graduated.
How long has it been roughly since then? Do you remember?
I guess since 1998. So about 23 years.
So let's talk about why we're all here today. Are you aware of an accident that occurred at Chimes on January 23rd, 2019?
Yes, ma'am, I am.
And what happened that day?
One of our employees fell off the loading dock in the back and was injured.
You mentioned that one of your employees fell off the dock. Do you remember which employee it was?
It was Jordan Gilmore.
Where did Miss Gilmore fall? Where was that dock?
It was the back of our store, our loading dock, where we brought all of our packages that were delivered, all of our store merchandise that was brought in.
After that incident, were there any changes met at Chimes?
After the incident, no, there were not.
And do you remember adding a light switch inside of the department?
Yes, inside we added a light switch, but we didn't do anything outside of the building.
Why didn't you do anything outside of the building?
We don't control that outside area. That is all controlled by our landlord, Kermit Realty.
Your Honor, I have a document which has been pre-admitted as Exhibit 11. Reference to this document can be found on page 134 of the electronic notebook. Mr. Patel, will you please post Exhibit 11 for the jury? Ms. Geller, do you have a copy of Exhibit 11 as well?
Yes, I do.
Now, directing your attention to that exhibit, do you recognize it?
Yes, I do.
What is it?
It is the lease that I signed.
And how do you recognize this lease?
I was involved in the negotiations for this lease along with my father when we signed it in 2005.
Now, let's talk specifically about Section 6.3 of this lease agreement. What does the lease agreement say about who's responsible for maintaining the loading dock?
It says the landlord should be responsible for any of the common areas, and this loading dock was in the common areas, so it was the responsibility of Kermit Realty.
So looking back at Section 6.1 in the lease, is that where the common area is defined?
Yes, it is.
Is that where loading areas are included in common areas?
Yes, it is.
Thank you, Mr. Patel. You may take down Exhibit 11. Now, let's talk about the structure of that loading dock that you had at Chimes. Are there guardrails at that loading dock?
No, there are not. For it to function properly as a loading dock, we wouldn't be able to have rails there.
Were there any railings on that dock before?
Previously, when we moved into the building, yes, there were.
Who removed them?
We requested for Kermit Realty to remove them as was required in our lease.
Why'd you ask them to have the railings removed?
The function of how it was set up with the railings, there was no physical way to get packages around the railings and into the building around the doors. So we needed the railing to be taken off in order to have a functioning loading dock for the store.
By taking these railings off, were you trying to make it unsafe for your employees by removing the railing?
Of course not. We were just trying to create a functional space for our business.
And what safety procedures does Chimes have in place for employees?
Well, we tell all of our employees to keep an eye out for any safety issues they may see and to immediately report them to us so that if there are safety issues, that we can take care of them.
Ms. Geller, to the best of your knowledge, who owns the land where Chimes is located?
To the best of my knowledge, it is Kermit Realty, our landlord.
Who did Chimes enter the lease agreement with?
With Kermit Realty.
Based on your understanding of the lease agreement, who must Chimes ask for permission before making any changes to the common areas?
That is again Kermit Realty.
Thank you, Ms. Geller. Your Honor, no further questions at this time.
Okay. Ms. Kasumsi, are you ready to cross this witness?
Yes, Your Honor. May I proceed?
Yes, you may.
Ms. Geller, you've been working for your family company since you graduated from college, haven't you?
Yes, ma'am, I have.
And you worked with your father when you were helping him with this company?
Yes, I started out as a buyer at the company.
And of course, you're aware of an email that your father sent to a landlord on behalf of the company that you were shown in your deposition.
If you're referring to our request to Kermit Realty, yes.
I am now pulling up what has been pre-admitted as Exhibit 13. Mr. Koenig, could you please pull that up? Now, Ms. Geller, this is that email that your father sent, isn't it?
Yes, ma'am, it is.
This is an email your father sent with a request to the landlord, right?
Yes, as we were required to do.
Yeah, a request to make drastic changes to the exit at the back of the building.
Yes, in order to make it functional for our business.
In this email, your father acknowledged that it was an emergency exit, didn't he?
Yes.
And in this email, your father requested that the landlord take out the railing.
Yes.
Thank you, Mr. Koenig. Now, Ms. Geller, after your father sent this email, the landlord removed the railings, didn't they?
They did.
They also paved a little driveway for you guys.
Yes, so that our trucks could back up to the loading dock.
Now, you keep talking about this common area and how you don't own it, but that email we just looked at shows us that if you request for a change can be made.
Yes, but that doesn't mean we own it. We don't own the property at all. We're just leasing it.
Ms. Geller, I'm aware. I acknowledge that you don't own it. But what I want you to answer for my question is that if you request a change, then it will be made.
It can be, yes.
Now, you make employees go out that what used to be an emergency exit and is now a makeshift loading dock for multiple reasons, right?
Yes.
You guys make them take out the trash out there.
Yes, that's where the dumpster is.
Now, this dumpster, that wasn't there when Chimes Department bought or started renting the property, was it?
No, it was not.
Chimes Department bought that dumpster.
Yes.
Chimes Department placed that dumpster in what you've said is an area you don't lease.
No, we don't lease it. It's a common area.
And you never asked permission to place that dumpster there from your landlord, did you?
No, but we were also not told that we couldn't have it there.
Now, you also designated this makeshift landing dock as a smoking area, didn't you, in 2015?
We told the employees that they couldn't smoke in the front of the building where customers were walking in and out. It had to be out of sight.
Well, actually, that memo that you saw earlier, it said that they had to smoke in the back, didn't it?
Yes, not in the front.
And though that makeshift landing dock are the only doors that lead out to the back of your department store.
I believe so.
And so when you decided that you were going to send out your employees out there for two different things, I mean, taking out the trash, wouldn't you say that happens every shift?
Pretty regularly, depending on the day, yes.
And so when you decided to send out your employees out those doors, you guys never requested that the landlord put a light out there?
No, we did not.
You never requested that the landlord put some railing on the stairwell?
No.
You never requested that the landlord put up some signs that say sudden drop?
No, we did not.
You never requested that the landlord put in maybe a removable chain where there's a drop?
No.
You never requested that the landlord put on some, bright tape around the edges of that platform?
No, we didn't.
You never requested that that landlord fix those steps that were falling apart?
No, we didn't.
So, Ms. Geller, you never requested that the landlord put any safety features when you were sending your employees back out there?
No, we didn't think that there was really a need. We were looking at it as a loading dock just for trucks to back in and out. We weren't considering it as an area where they hang out or anything like that.
You were considering a loading dock that you also sent other employees out there for multiple reasons, right?
Yes.
And just to clarify, Chimes department store doesn't ever inspect the premises around or in the building for safety issues, right?
Not on a regular basis, but like I said earlier, we keep our eyes out and our employees do as well for any safety issues.
But according to you, you don't ever inspect the premises around the building for safety issues. Isn't that right?
Correct. Solely for that issue, we don't.
Because in your words, you're not a safety company.
Correct. We're worried about we're a merchandise department store.
No further questions, Your Honor.
Any redirect, Ms. Hawken?
Yes, Your Honor. Ms. Geller, you were asked about whether the store had taken various steps to add things on the loading dock. To your knowledge, had Chimes ever received notice that you were in violation of any federal standards with regard to that loading dock?
No, not at all.
Thank you, Ms. Geller. Your Honor, no further questions. May this witness be excused?
Yes. Ms. Geller, you may be excused. Do you have another witness to call?
Yes, Your Honor. Pursuant to the rules in this jurisdiction, we would like to call Perry Hayden as a deposition witness.
You may proceed when you're ready.
Starting on page 2, lines 5 to 6. Good afternoon. Please state your name for the record.
Good afternoon. My name is Perry Hayden.
Line 11, question, what do you do for a living?
I'm a compliance safety and health officer with the Occupational Safety and Health Administration.
Line 14, what does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is a government agency that is responsible for making sure that the workplaces are safe for the employees that work there. So we provide information, training, and assistance to employees and employers to try to make workplaces as safe as possible and to make sure those workplaces are in compliance with OSHA regulations and standards. We're all about employee safety.
Line 22. And what do you do at OSHA as a compliance, safety, and health officer?
I'm one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
Page 3, line 4. What happens if a workplace doesn't comply with those OSHA standards?
Well, there's lots of potential implications, but at the very least, it would result in a citation for any violations that we find.
Line 16. How long have you worked for OSHA?
Since I got out of school, so at this point, that's about 13 years.
Line 19. And over time, how many inspections have you conducted?
Oh man, hundreds, thousands? I mean, the answer is a lot. It's basically my entire job, so I'm always out on the road inspecting somewhere. It's an everyday thing.
Line 23 on page 3. What kind of education did you receive before becoming an inspector for OSHA?
I graduated from high school and then I went on to Texas State Technical College where I got an associate's degree in occupational safety compliance technology. Then I went on and got a second associate's degree in environmental technology compliance.
What are those degrees about?
Well, these are really about training programs dealing with the hazards of machines, safe work methods, environmental hazards, workplace hazards, and various safety issues. These are literally the degrees you need if you want to do something like work for OSHA.
Page 4, line 12. Have you ever testified in a lawsuit before?
No, first time.
Line 14. How did you end up being involved in this case?
I got a subpoena from you and it told me to show up here. So that's what I did.
Page 5, line 1. Are you being paid by anyone for your time today?
Nope.
Line 3. Have you been retained by anyone to serve as an expert in this case?
Nope.
Line 6. All right, Mr. Hayden, how are you involved in this case?
Well, I conducted an inspection at that Chimes department store in Waco back in 2018. So I assume that's why I'm here.
Line 16. Why did you inspect the Chimes department store in Waco back in 2018?
It was just a regularly scheduled inspection. We do that all the time. Just show up and do an inspection.
Line 20. So were there any complaints that led to this inspection?
Not that I'm aware of.
Line 23. During that inspection, what were you looking for?
At the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there is a little landing area and some steps?
Yes, I did.
Page 6, line 14. Why did you inspect that area?
The manager at Times that day told me that the employees regularly worked in that area behind the store and took smoke breaks there. So once I had that information, I made sure to include it on my list of areas to inspect.
Line 22. When you went out there, what did you notice about the steps and the landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
If there were such obvious safety issues, why didn't you issue any citations?
The manager told me that there used to be guardrails, but they were removed because Chimes used that landing area as a loading dock.
Page 7, line 16. Why does that matter?
Because loading docks don't have to have guardrails.
Page 8, line 20. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 910.28B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar in your way.
Page 9, line 1. Have you had the chance to review the deposition of Kelly Danes?
Yes, I have.
Well, what do you have to say about all of the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of that landing area in the back of the store?
None of them deal with loading docks, which is what Chimes was using this area as. This wasn't just a stairwell or just a landing area at the top of a stairwell. This was a loading dock, and the provisions cited by Kelly Danes don't deal with loading docks.
Was this area behind the store exclusively used as a loading dock?
No, but I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes used this area as a loading dock. That's what matters.
Your Honor, that concludes our reading of this witness's deposition.
Okay. Ms. Kasemsi, any questions for this witness?
Yes, Your Honor. And just to clarify for the jury, we're going to be rereading a couple of lines that opposing counsel just read, but we're going to be reading a whole answer, whereas opposing counsel only read part of the answer. Directing your attention to page 7, line 9. Question: if there were such obvious safety issues, why didn't you issue any citations?
As I said, I got pretty alarmed. So I asked the manager that was walking around with me during the inspection about the fact that there were no guardrails and about the cracked concrete. The manager told me that there used to be guardrails, but they were removed because Chimes used that landing area as a loading dock.
No further questions, Your Honor.
Okay. Any redirect, Ms. Sahakin?
No, Your Honor, that concludes this witness's testimony.
Okay, then this witness will be excused. And that, I guess, if you are ready to close your case in chiefs, then we can proceed with closing arguments.
The plaintiff is ready, Your Honor.
Okay.
The defense is ready, Your Honor.
Okay. Well, if you would, let's see, let me give you a quick just time update since mine is going to be the official time. Ms. Kasemsi, I have you at 40 minutes and 30 seconds. So you'll have about 15 minutes left.
Yes,
and Ms. Hagen, I have you at, let's see, 32 and a half minutes. So you have quite a bit of time. So I will keep the official time and I will cut you off at exactly 55 minutes if you get that far. Okay.
Thank you, Your Honor.
Yes, Your Honor. Excuse me if I readjust.
Yeah, of course.
And Your Honor, at this time, the plaintiff would just like to reserve any leftover time we have for a rebuttal.
Okay, will do. Let's see. Just a second. Okay, you may begin.
May it please the court. Business first, safety last. As you saw today, this was the mindset and the practice of the defendant. And that mindset and practice is what brought us here today. Business first and safety last resulted in the defendant creating a hazardous area with unreasonable risks. That loading dock was not meant to be a loading dock, but that defendant made it one and didn't do anything else about it. Business first and safety last is what led the defendant to force his employees to go out there every day for multiple tasks. Business first and safety last led to the defendant choosing not to do anything about the conditions they had created when they turned that emergency exit into a makeshift loading dock. I want to take you back to the day that Miss Jordan Gilmore was injured, January 23rd, 2019. As you heard, Miss Gilmore was one of her long shifts, 12 to 8 p.m. And she and a friend decided to go back there to take a smoke break. You heard today, members of the jury, that Jordan Gilmore and her coworker had no other choice but to go onto that makeshift loading dock for that smoke break. Why? Because the defendant wanted to make sure that there was no smoking at the front of the store. And so they forced all their employees to go back there. So Jordan and Riley go out there. It's cold, it's windy. And Jordan Gilmore walks down those steps. And as she told you about today, she held on to that wall to steady herself because there was no railing. There was no railing not only around the platform, but around the stairs. They took their break, and as they went back up, Jordan Gilmore held on to that wall again as she walked up those stairs in the dark. Her friend Riley was holding the door open against the wind. As Miss Gilmore tried to get back inside to get back to her shift, she fell and injured herself because of all the unreasonable risks. This landing that was crumbling, as you saw today, these stairs that had things protruding from them, the pitch blackness out there. You heard about all of that. Now, in order to meet our burden today, we had to show you 3 things. And when you get your jury charge today, it's going to talk about those 3 things that we had to show in order to meet our burden. We had to show that 1, the condition in question posed an unreasonable risk of harm. So I want to go through all the evidence you saw today. First, you heard from Jordan Gilmore, who showed you that loading dock, first and foremost, who showed you the piping and the wires sticking out from the platform, who told you about how there were no lights, who told you about how in the picture you can see fire exit. Yet not a single time Miss Gilmore went outside, an alarm went off. You heard about how, from the own defendant's witness, Perry Hayden, that when he went out there, he was shocked about the crumbling concrete and how there was no railing anywhere in sight. Members of the jury, this was an unreasonable risk, but not only an unreasonable risk to the people loading the dock, but an unreasonable risk to the employees that the defendant was forcing to go out there to take out the trash, to take their smoke breaks. Second, we had to show you that Chimes department store knew or should have known about this unreasonable risk. Now, members of the jury, when Jordan Gilmore came to the stand today, Jordan Gilmore talked about how much they use that. They use that for unloading and loading their stuff every day. Jordan Gilmore talked to you about how they decided to buy a dumpster and put it back there. They had seen it. They had seen that condition. And Jordan Gilmore told you about how Chimes department store, the defendant in today's case, were the one who chose to remove that railing. You heard today that the Chimes department store manager told the employees, "I'm sorry, we have no control over that light. It's pitch black back there." And once again, to emphasize that the defendant not only should have known, but knew, you heard today that Perry Hayden was talking to a manager for the defendant about the falling apart that he saw everywhere back there where employees were sent all the time. And third, we had to prove to you that Chimes department store failed to exercise reasonable care to protect their employees from the unreasonable risk. Today, you heard a lot about ownership. You heard a lot about leasing. You heard a lot about who had control directly of this area. But members of the jury, do not forget that first piece of evidence I pulled up when Reese Geller was on the stand. The email from the defendant simply asking the landlord to remove the railing. And guess what happened? It was removed. It was simple as that. But in that email, as you can see, it says that the defendant reimbursed the landlord. So they could get changes done if they simply requested it, but at a cost to themselves. And that, members of the jury, is the reason why the defendant chose not to address the unreasonable risk by simply emailing their landlord. They could have emailed their landlord to put an extra light. They could have emailed their landlord to put some railing on the stairwell. They could have emailed their landlord just to put some paint right there on all the edges that dropped off. Members of the jury, they could have emailed their landlord anything to make that safer, but they did nothing. We had to prove these three things to you by preponderance of the evidence. And like I said, it's the tipping of the scales ever so slightly. But as I just explained, all the factors we provided to prove these claims is that those scales tip much more than slightly in our favor. Members of the jury, we have met our burden. But we were not the only ones who had to prove something to you today, because the defendant has chosen to put Jordan Gilmore and the realtor also on your jury charts today. They had to prove to you those three things. Members of the jury, don't be distracted by all these excuses. The excuses about leasing that area, about owning that area, because we showed you over and over and over again that they knew about these conditions, and one email could have changed that. Members of the jury, when the defendant decided to put business first and safety second, actually, safety last, they created a hazardous place. They forced their employees to go out there, and then they chose not to just send one simple email. They chose not to request to make that place safer in any way. But after Jordan Gilmore fell, the defendant added a light switch, which once again was inside the building, but that light switch turned on that light outside. So when is the defendant willing to fix things? Well, we saw after Jordan Gilmore fell and brought this suit, that's when they decided to. So they did have the power to affect that area this whole time on their own. And like you heard, when they put that dumpster out there, they did that without the landlord's permission. They could have put cones at the edge of that platform. But once again, all I'm talking about are simple things the defendant could have done if they really wanted to make sure that their place of employment was safe for their employees. And they didn't. When the defendant comes up here, I don't want you to be distracted by all this legal jargon of common area and the lease and all of that. I just want you to focus on what you know. That one request from the landlord immediately got results. Hold the defendant liable for putting business first and safety last by finding the defendant liable in today's case. Thank you.
You may proceed, Ms. Hawken.
When a person gets injured, It's only natural to want to place the blame on someone else. It's natural to want to hold someone accountable. But in this court and under this system of justice, it's not just about holding anyone responsible. It's about holding the right people responsible. And today you learned that it was Kermit Realty who was in charge of maintaining, repairing, and inspecting that loading dock and making sure that it was safe for all of the tenants in that shopping center, not just Chimes. And as hard as it is to say, and as difficult as it may be for Miss Gilmore to hear, it was Miss Gilmore's decisions that ultimately led to that accident. Because hasty decisions can lead to harsh consequences. Now, the issue for you to decide is whether Chimes will be held responsible for the terrible choices Kermit Realty and the plaintiff made. As Judge Chavez will instruct you, the plaintiff had a burden to prove that Miss Gilmore's injuries were the result of Chimes's negligence. Members of the jury today, they failed to meet that burden because instead the evidence has shown two things. First, that Chimes isn't even the party that's responsible for maintaining the loading area. And second, that it was the plaintiff's own choices that led to her injury. So let's take a look at that first thing the evidence showed, that Chimes isn't even the party that was responsible for maintaining the loading area. Today you heard from Reese Geller, who told you how she worked her way up the ladder of her family's company and how she came into this lease. And she told you that she negotiated this lease with their landlord and they came to a mutual understanding about what was required of both of them. In fact, in that lease, you saw that section 6.3 designates that common areas are to be maintained by the landlord for all tenants. And those common areas, well, they included the loading dock areas. And as an experienced landlord in a shopping center, Kermit Realty knew that. But as an added measure, Chimes required their employees to report anything dangerous they happened to see at work. Members of the jury, you even actually heard from someone who works closely with the OSHA statutes, Perry Hayden. And Mr. Hayden is an officer for OSHA for over 13 years. He's conducted thousands of inspections during his time at OSHA. His old job was to make sure that the employer maintains the workplace in a way that complies with OSHA. And if not, they give out citations. And when he actually went to Chimes in 2018, he didn't find anything wrong with that loading dock. But of course, the plaintiff doesn't want you to believe that. They want you to think that Chimes knew or could have known that this loading dock would have posed a risk to their employees. But Mr. Hayden told you that the sections in the code clearly state that guardrails, well, they're not required for loading docks because they aren't feasible. Think about it, members of the jury. How can a store move in items if there's a railing blocking the loading dock? That's just common sense. And Mr. Hayden told you that just because people eat a sandwich on it, it doesn't turn into a diner, and he's right. That doesn't change the main functionality as a loading dock for the store. But then they tried to say that our expert who does consulting services realized that there was something wrong with that area and failed to do something about it. But remember, members of the jury, Mr. Hayden has no horse in this race. He got subpoenaed to come testify. And the worst thing they could say about him was that he was too lenient. They tried to make you think that there was this big issue about those doors being a fire exit. But do you really think if those doors led to a fire exit, That an officer from OSHA would go there and just simply ignore that? Members of the jury, there would have been a citation immediately. But you know that doesn't make any sense because that wasn't used as a fire exit. That was converted to become a loading dock. Then the plaintiff tried to make a big deal about the fact that Chimes ended up adding a light switch in their company. Tried to say that just because they moved that light switch into their department, that somehow they controlled it. Yet what they want you to completely ignore is that Ms. Geller told you that it was Kermit Realty who was in charge of that area. It wasn't up to Chimes to make those changes and to maintain the dock. They had a contract, and Kermit Realty failed to uphold their end of the bargain. And so that brings me to the second thing the evidence has shown, that it was the plaintiff's own choices that led to her injury. Members of the jury, we can all agree what happened to her was terrible. But as terrible as it was, under the law, you have to consider those actions and how they contributed to this accident. Because we took up the affirmative defense of comparative negligence. You basically have to judge Ms. Gilmore's actions based on how a reasonable person would act in that same situation. This wasn't about business. This was about a careless employee who knew exactly where those dangerous situations were. Geller told you, we always instruct our employees they should look out for any safety issues. If they see anything that worries them, they should report it to management immediately. Had management received any complaints about that loading dock? No. Even Ms. Gilmore told you she's been out there plenty of times. She's never had an issue. She wasn't just a new employee who didn't know what she was doing. She had been there for over 10 years. Smoked a pack a day. That was a regular occurrence for her. You have to judge her actions based on what a reasonable person would do. And you have the best reasonable person who was standing right next to her, her coworker. When her coworker walked out there and saw that it was dark, it was windy, and it was cold, her coworker didn't go down those stairs. Members of the jury, she knew that the light wouldn't be on because it was a regular occurrence to her in her own words. Now, in a moment, as opposing counsel said, you're going to be asked to complete this jury charge. And here you see one question. Did the negligence of any of these parties proximately cause the occurrence or injury in question? Based on the evidence you heard today, you know that Chimes didn't control the loading dock. They never leased that land. So they couldn't make whatever changes they wanted whenever they wanted. They had to get Kermit Realty's permission. And because they couldn't make those changes, they weren't the cause of this injury. So we ask you to write no next to their name. Rather, you learned that Kermit Realty owned the loading dock land. They could have made the changes to the dock instead of approving the change to take off the rails. Changes that maybe could have prevented this injury, but they didn't. That's why we ask you to write yes on the second line. And unfortunately, you also heard that the plaintiff had rash decisions ignoring common sense. Walking in the dark, not opening the door fully, and not rushing back up those stairs. That's why we ask you to write yes next to the plaintiff's name. And on the following page, you will be asked to determine the percentage of how much Kermit Realty and the plaintiff are liable. Now, we trust that you will use your common sense to assign proper values to both Kermit Realty and the plaintiff. Members of the jury, under this system of justice, We don't just hold someone responsible, we hold the right person responsible. Chimes and Miss Geller relied on Kermit Realty to keep their promise to ensure their store was safe. And unfortunately, with the combination of the plaintiff's hasty decision, it led to harsh consequences. Now, as a juror in this case, you have the duty to make sure your decision isn't a hasty one and that you hold the right people responsible for this accident. Find the defendant not liable.
Ms. Kasemsi, you have 3 minutes and 30 seconds left for your rebuttal.
Thank you, Your Honor. May I proceed?
Yes, you may.
Members of the jury, we're not here today because of hasty decisions. We're here today because of calculated decisions. The decision of the defendant to send an email to their landlord. The decision to turn an emergency exit into a makeshift loading dock. And the decision to willingly pay for that change. We're here because of this decision to make that area so much more than a loading dock. To make that area somewhere that employees had to go all the time. We're here today too because of the decision to label that area as simply a loading dock for regulatory purposes, so that the defendant didn't have to make any alterations, even though we all know it was used much more than simply a loading dock. We're here because of the decisions to not send a single email to the landlord, to add just one safety feature to an area that was used much more than for simply a loading dock. We are here because of calculated decisions to put business first and safety last. Members of the jury, when you look at that jury charge, do not forget that in order for the defendant to meet their burden, they also had to show those 3 things for Kermit Realty Group. And ask yourself, who created that unreasonable risk? Who knew about that unreasonable risk? And who had the power to use their knowledge in order to make changes to that area? Find the defendant liable.
Okay, and with that, that ends our trial today for Gilmore versus Chimes. Judges, if our scoring judges, if you would take a couple of moments now to fill out your ballots and get those sent into our tabulation room. Our participants, you did an excellent job. Go ahead and take a brief break. And as soon as while we're waiting for our go ahead that everyone's scores have been calculated, the judges will come in and give you guys a few comments. Right. If everyone's ready, our scoring judges can come back on and give some brief comments if they would like.
Hello, that was awesome. Thank you both very much. I'll let the other judges.
Oh, I can jump in, Barbara. I thought both teams did a great job. Both of the lead advocates were very well spoken and had a good tone, a good style. I particularly liked the cross-examination style of both of you and had real troubles judging cross. I thought you both did an admirable job with witnesses who probably gave you some surprising answers. And of course, a judge who maybe gave you a surprising ruling, at least at one point. So great work, and I really enjoyed watching you.
Thank you.
Thank you. Yeah, both of you guys did a great job. I know it's hard in this format to gin up a lot of excitement, but you did a very proficient job, both of you. Rima, and this is for both of you, whoever's continuing on to the next round. I thought it was good that you introduced your client on your opening statement. I thought that was good. I think that would help, again, either one of you that's going forward to do that. Rima, I also thought on your closing, it was good form and helpful to put up the jury verdict form. So you could give the jury sort of a roadmap of what you felt the evidence led them to do. I thought that was helpful. I thought, Rima, your presentation was reserved and understated, which is always good for the defense. And Jackie, I thought your animation and passion, and this may be just me, I like the fact you stood up when you did your argument. I don't know why that impressed me, but I thought that was a good touch. And you had a very good, passionate delivery, which is always helpful for the plaintiff. And those are my comments.
Thank you for judging.
I think you all did a really good job. One of the things I'll say, and it's for both of you, remember to, when you say you're going to prove something, make sure you prove it. So if you have don't be too strong on something if you know the evidence isn't going to get you there, especially with the mock trial stuff. Try to downplay it just a little bit and then hit the high notes. So basically under-deliver, over-perform. Is that how that saying goes? I always mess up those sayings. But I am a defense attorney by trade. I completely agreed. I am stealing this from you, Rima. I absolutely loved it. Hasty decisions can lead to harsh consequences. Honestly, like I am going to use that. I really enjoyed that. No, really, it's always a pleasure judging you all and seeing what the next generation's gonna look like and teach us. So thank you so much.
Guess I'm last. So I thought y'all did a great job, both of you. So thanks so much for all the work that y'all put into it in a short period of time, I know, and that's impressive. Y'all both seem to understand the case very well, given the nature of the competition. So, knowledge of the facts and the law is the main thing. So great work, both of you, on that. If I had to give one suggestion to each of you, which is what we were recommended to do, is it pronounced Jackie? Plaintiff's lawyer?
It's pronounced Jack, but it's
Jack,
hard to know that.
Okay. So Jack, just on cross-examination, at times you'd get a little long with your questions. The best part of the crosses is when it's, short, leading questions, just bam, bam, bam. And so that's my only suggestion there. And Rima, for the defense counsel, I thought you did great. There were a couple, I know the evidence stuff in mock trial is a little different. There were a couple, I thought, evidentiary issues that you could have jumped on, maybe instead of others that you focused on that. So just make sure you're paying close attention the whole time on some of that. So, but I thought y'all did a great job and really enjoyed it.
Well, I received notice from the tabulation room that all of your ballots successfully came in, so you are all free to leave. Both Jack and Rima, I wish you best of luck in your next round. And I think, judges, if you are coming back for a second round, 2:30 is kind of our check-in time. So we'll see y'all a little bit later.
Thank you for judging.
Thank
You're
you.
welcome.
Bye, everybody.
Rima, thank you for letting me butcher your name for the majority of our trial.
You actually hit the nail on the head.
Okay.
So thank you.
Good luck, y'all.
Good luck, guys.
Judge, so we're not waiting here like last time that they told us to kind of wait. We get off and come back on.
I believe so. I'm supposed to keep
everyone
this
left.
running. Everyone left, but I think that they gave you separate links because you might be in a different courtroom for the next round. Not quite sure how that one's working.
I'm sure it's in my email. Thank you.
You're welcome.
Hello, everyone. I'm the judge, but I'm taking roll now based on the roster that I have here. So if y'all will bear with me for a minute, then I'll be ready shortly. Oh, there he is.
Sorry about that, Greg. I couldn't hear you for a second, so I left and came back.
All right. Anybody else having any technical difficulties? Can you hear and see me? Okay. Is anybody feeling like they're missing someone? Okay.
Professor Wyatt, Tara, and I are here.
Okay, very good. Thank you. I think that our rule is going to be that if you're not, if you're judging or a witness in waiting, if you'll turn your video off, so we'll have fewer faces up there. And if you are counsel on the case, I need you to be visible all the time. And I'm going to stay visible all the time. My name is Greg White. I'll be your judge today. And I am ready whenever counsel are to take up pretrial matters.
Your Honor, plaintiff is ready for appearances.
Okay.
Good afternoon, Your Honor. My name is Rima Sahakian, and along with my co-counsel, Darshan Patel, we represent the plaintiff in this matter, Ms. Jordan Gilmore.
Thank you. Defense announcements?
Good afternoon, Your Honor. My name is Jenna Forster. I'm here with my co-counsel, Cheyenne Smith. Together, we represent the defendant, Chimes Department Store.
Very good. Are there any matters we need to take up before opening statements?
Yes, Your Honor. A few housekeeping matters as well as substantive motions.
All right. Did the defense going to have anything, or has your meet and confer resolved things?
Your Honor, we may have a couple housekeeping matters depending on what the plaintiff handles, and then we do have a motion or two to bring up.
All right. So I'll let the plaintiffs go first with their pretrial matters.
Your Honor, the exhibits in this trial have been pre-marked and they have numbers that are given to them in the packet. They may come in out of order. We just ask that those exhibits retain those numbers so that we can easily identify them.
That seems reasonable to me. Any objection to that?
None.
Fine. Other matters?
Yes, Your Honor. During the course of trial, counsel may ask to approach for sidebar. We ask that we do this constructively so that the other evaluators may hear our arguments.
Of course.
And Your Honor, during meet and confer, opposing counsel and I were able to stipulate to the admissibility of some exhibits. I can give Your Honor the numbers of the exhibits, and we would like to ask Your Honor to pre-admit them.
I have my list in front of me, so go ahead.
Your Honor, that would include Exhibit 2, Exhibit 3, 4, 5, 6, and 7. It would also include exhibits number 16 through 35.
Oh, I have to make a lot of checks. Hang on. All right, I'm down to 35. Any others?
Your Honor, other than that, may we also have a brief moment to give our witnesses notice about the outcome of any pretrial motions that are substantive?
That would be fine. We'll take a couple of minutes in between the pretrial and the beginning of opening statements.
Yes, Your Honor. With that,
let me ask this before you go forward. To defense counsel, she read off a list, plaintiff's counsel read off a list of exhibits. Does that coincide with your list?
It absolutely does.
All right, so the court will announce that those exhibits that were listed are admitted. No further authentication or talking with the witness about their admissibility is necessary. I have 2, 3, 4, 5, 6, 7. I have 16 through 35. Those are admitted.
Yes, Your Honor. We'd also like to ask Your Honor's preference about formally tendering the expert witnesses in this case. The rules of the jurisdiction as of now have made these witnesses deposition witnesses, and therefore we will be reading the statements of these witnesses off of their depositions.
I think that's a matter of your choice. If you feel like the jury needs to know that those persons are offering opinions or have special expertise, I think you need to let them know that. But as far as I'm concerned, I don't care which way you handle it.
Yes, Your Honor. And with that, the plaintiff is ready for substantive motions.
All right.
Just a couple of housekeeping matters before we get to substantive motions, if that's all right with Your Honor.
Sure.
Firstly, for any exhibits where we haven't stipulated to their admissibility, would you prefer that we lay the foundation to offer those into evidence before we share them on the screen, or can we share them on the screen constructively outside the views of the jury in order to lay that foundation?
Why don't we try and do it without sharing the screen? And if I am unable to make a ruling based on what I've heard, I will ask you to share the screen so that I can see it. We will consider that for purposes of the record to be constructive until I've made a formal ruling, either admitting it or excluding it. Does that cause you any technical problems to do it that way?
That works for us.
All right, fine.
Second, can we have your permission to use some of the pre-admitted exhibits during opening statements?
Have you discussed that with opposing counsel?
We haven't yet, Your Honor.
All right. Is there any reason that either of you would object to the use of admitted exhibits in opening statements?
None from the plaintiff, Your Honor.
All right. Then your request is granted. You may use them in opening statements, the ones that we've numbered.
Thank you.
Admitted.
We have a couple of substantive matters, but I'll let the plaintiff go first with theirs.
All right.
Your Honor, this is a case about a company that required its employees to work near loading docks that it didn't inspect, maintain, or upkeep. This defendant had the duty to ensure that these docks were safe since they were being used as an area where employees took breaks, as well as an area where employees took out trash. As a result of these dangerous working conditions, the plaintiff, Jordan Gilmore, was severely injured during work hours. Your Honor, our first motion is to exclude any mention of the defendant receiving a citation or the lack of a citation from the Occupational Safety and Hazard Administration. Now, by way of background, we have a good faith belief that the defendant will call a witness who is an OSHA officer. This individual went to Chime's department store and they did not issue a citation upon inspection of the store. Your Honor, we move to exclude the non-citation under Rule 403 as it is substantially more prejudicial than probative. The members of the jury are going to think that just because the defendant did not receive a citation, that they are not negligent in this case. However, the standards for OSHA and the standards for negligence are wholly different. We don't have an expert witness in this case that can opine as to how different the legal standards are, and therefore that will mislead the members of the jury.
All right, and I'm construing that as a motion in limine?
Yes, Your Honor.
All right, I'll grant that motion in limine. I understand the issue well enough to not require a response from the defendant. So I feel like I understand that. I'm going to grant the motion in limine. If you want to bring that up, let's talk about it when it comes up in the middle of the trial and see where we are in the evidence.
Understood, Your Honor.
Anything further from the plaintiff?
No further motions from the plaintiff, Your Honor. We're ready for trial.
All right. Does the defense have any motions?
Yes, Your Honor. First, we would ask you to take judicial notice of a particular provision of law. And I can go ahead and share that on a slide for you if you'd like to see it.
Tell me what it is before you share it. What is it?
Sure. It's International Building Code Section 1012.1, which states that no guardrails are required on loading docks.
All right. I don't need to see it. I had a chance to review the file before trial began, so I'm familiar with it. Proceed.
Second, the defense moves to exclude any mention of an installation of a light switch to an outdoor light inside the Chimes department store after the date of the plaintiff's accident. This evidence is inadmissible under Rule 407, which bars use of subsequent remedial measures to prove negligence. That is the only relevant reason for which the plaintiff could offer it today. And for that reason, any mention of this testimony, it's just inadmissible.
All right. As I understand it, the installation of the light bulb is not a fact that's in dispute. So plaintiff, why would you be allowed to admit that?
Your Honor, we will be using this evidence not to show negligence, rather we will be using it to show that the defendant actually had control over the loading dock area and that it was feasible as permitted under Rule 407. Your Honor, even though the defendant does not plan to dispute those issues, we would like to ask for a stipulation from Your Honor in that case to be able to argue to the members of the jury that so long as they had control before the accident occurred, that it was under their control and it was feasible for them to install the light bulb before the accident ever happened, that we be allowed to do so.
All right, I'm going to grant the motion in limine on that issue the same way that I did on the OSHA issue. If that comes up and we want to talk about it, then somebody needs to approach the bench before the witness is brought. That subject is discussed with the witness.
Understood. And nothing further from the defense. We're ready to proceed to openings.
All right. You know, I would compliment counsel. You have been very efficient in the pretrial, so I'm going to give you 2 full minutes to get prepared for opening statements, and I'll go put my robe on and act like a judge from this point forward. Anybody that wants to can turn off their camera, but be back in 2 minutes.
Yes, Your Honor.
All right. Counsel, are y'all ready to proceed?
Yes, Your Honor. Plaintiff
Let me take
is ready.
up just a few little technical details, and I probably should have done this pre-trial, and I'm not on the clock right now. I am keeping time because of the court's restrictions on your use of time in trying this case. I'm going to do my best to do it correctly. If for some reason your timekeeping differs from mine substantially at some point, I'm happy to listen to requests for additional time as long as it's minor. I mean, if you're a minute off from me, then I think we might be able to make an arrangement about how you can get the time back that you think you deserve. If you're 15 minutes off from me, I don't want to hear that one. I'm not going to mess up that bad. The second one is before we begin the actual presentation of witness testimony, I'd like for each of y'all to exhibit a admitted exhibit on the screen so that everyone can see what that's going to look like and make sure that the view that they've got is consistent with what they want, and they don't have to concentrate on some kind of technical thing to be able to see the exhibit the way they want to. Is that suitable with y'all?
That works, Your Honor.
Okay.
That is, Your Honor. And since we plan to use exhibits, admitted exhibits during opening statements, do you mind if we go ahead and do that now quickly?
Let's do that now. So on the plaintiff's side, would you put an exhibit up on share one on the screen?
Mr. Patel, will you please share an exhibit for me? Thank you.
Okay. Is that a technical view that everybody's happy with?
Looks great to me, Your Honor.
Okay. Defense counsel, Ms. Forster?
Sure.
Okay. All right. So plaintiff's exhibit can go down 17. Defense counsel, can y'all show one? Okay. Same view. So we're fine. So our technical people have got us all under control and we can proceed without worrying now. Are there any other technical things y'all would like to test before we go on? I don't want to stop in the middle and have some kind of problem about it. You think we're all right?
Your Honor, I will just note that between statements and examinations, I'll turn my camera off briefly to adjust it, but it should be pretty quick and shouldn't interrupt anything.
I understand. And that's on you. If you bore us, then that's your problem, not ours.
Understood.
Okay, fair enough. All right. So I believe we're ready to hear opening statements. Am I right?
Yes, Your Honor.
I'll hear first from the plaintiff. Thank you.
With risks comes responsibility. The defendant Chimes department store was more than willing to take risks with their employees' safety. But when those risks led to injuries, serious injuries, to their employee, Jordan Gilmore, the defendant now turns around and refuses to take responsibility for what they did. Instead, they come to this court today and they try to blame the very person they placed in danger. Members of the jury, the issue for you to decide today is whether the defendant will finally be held accountable for the dangerous risks they took and the tragic results suffered by Ms. Gilmore. But before you hear more about what happened to Ms. Gilmore, I want you to meet her. Ms. Gilmore, will you please turn on your camera? Members of the jury, this is Jordan Gilmore. She's a lifetime resident of Waco who's been a loyal employee at Chimes department store for the last 10 years. She works as a cashier. Today, she'll tell you that on the evening of January 23rd, 2019, she was taking a smoke break outside on the loading dock behind the store. And when she walked up the stairs to head back to work, the dangerous conditions that the defendant allowed to develop on their property caused her to fall off the dock, causing an injury that changed her life forever. An injury that the defendant could have predicted and should have prevented. Thank you, Ms. Gilmore. Now, as Judge White will instruct you, the defendant had a duty to properly maintain and inspect their property, including that loading dock. Today, we'll prove by the greater weight of the evidence that they breached that duty by establishing three things. First, that the defendant knew that their loading dock was dangerous. Second, that they did nothing to fix that dangerous condition. And third, that it was the defendant's negligence that led to Ms. Gilmore's injury. So let's talk about that first thing the evidence will show, that the defendant knew their dock was dangerous. Today, you'll hear the deposition testimony of Kelly Danes, an expert in mechanical engineering who specializes in safety regulations. You'll hear that she went to the site where Miss Gilmore fell and determined that the loading dock had several problems. No railing on the stairs, no railing on the platform, and it didn't even have proper lighting. Ms. Danes will explain that the Occupational Safety and Health Administration, or OSHA for short, has laws employers have to follow to make sure that those necessary railings exist in the areas that need them. You'll also learn that once the sun goes down, the area where Miss Gilmore fell becomes pitch dark. And the only switch for the one light that's outside, it's in the store next door, where none of the defendant's employees can access it. You'll learn that the defendant knew this was a problem. And other employees repeatedly complained about these issues to their manager. But members of the jury, they were told the defendant can't do anything about it. Instead of fixing those issues, the defendant gambled with the safety of their employees. And they lost. And so that brings me to the second thing the evidence will show, that the defendant did nothing to fix those dangerous conditions. Members of the jury, today you'll learn that the defendant is the one who removed the railings from that dock in the first place. The Walmart that had rented the space before had kept those railings. And you'll see the email where the defendant asked their landlord to remove them 2 weeks after moving in. And that's important because you certainly won't see any emails where the defendant asked their landlord to make the area safer. The defendant will be forced to admit to you today that Chime's department store used that area the most. That's how employees threw out the trash. That's where they went for their smoking breaks. And that's where they received deliveries. And you'll see that they knew that these stairs were in that condition. But they did nothing to keep their employees out of harm's way. And so that brings me to the third thing the evidence will show, that it was the defendant's negligence that caused Ms. Gilmore's injuries. But to understand that, we have to go back to January 23rd, 2019. And Ms. Gilmore will take the stand and she'll tell you that it was a cold January evening and that she was about to finish her shift for the night. She goes outside to the loading dock area with her coworker to take the breaks that the defendant told them where to take those breaks, in that area with no lighting. And as she starts to climb up the steps to head back to work, she doesn't make it. Instead, Miss Gilmore falls off of the platform with no railing to catch her, causing an injury requiring 28 staples to close up her leg and requiring surgery to completely replace her right knee. An injury that you'll learn could have been avoided had the defendant just taken the proper steps to protect their employees. Members of the jury, the defendant failed to protect Jordan Gilmore when they chose risks and they gambled with her safety that night. Now it's time for the defendant to take responsibility for their dangerous choices and the disastrous consequences that Jordan Gilmore suffered and will continue to suffer. That's why at the end of this trial, I'll come before you and I'll ask you to find the only verdict, consistent with the evidence and demanded by justice. A verdict finding the defendant liable.
Does the defense wish to give an opening statement?
We do. May I proceed?
You may.
The steps were safe if the employees were safe. Today you are going to hear about Chimes department store located here in Waco. You are going to hear about the loading dock set up at the back of that store. And you are going to hear that on January 23rd, 2019, the plaintiff, Jordan Gilmore, fell off that dock and she got hurt. But folks, what the evidence will show is that those steps weren't dangerous if the employees were being careful. The steps were safe if the employees were safe. Now, today you're going to learn a lot about Chimes department store, the defendant, my client. You're going to meet Reese Geller. Ms. Geller is the owner of Chimes. She'll tell you she is the third generation of Gellers to own that store. It was started by her grandparents, then her parents took over. 10 years ago, she took over. Chimes is a family business, a Waco institution. Ms. Geller is going to tell you that back in 2005, Chimes was doing really well. Business was booming. They needed to expand. So they looked for a new place to set up shop. And what they found was the location that the store still sits in today, in downtown Waco on Bosque Avenue. You're going to hear that at the time that they signed the lease and started to set up shop, they realized they were going to need a modification to that store to make it work for them. So you're going to hear that the store had a front entrance, it had a back exit, but it didn't have a loading dock. You'll hear you just can't run a department store without a loading dock. So Chimes put in a request with the landlord. They put in a request to have a railing removed from the loading dock at the back of that store and to have a concrete driveway put in so that trucks could drive right back up to that loading dock so that people could offload items, inventory, carry them into that store. You're going to hear that happen in 2005, 14 years ago. You'll hear that for 14 years, every single day, day after day after day, employees used that loading dock. You're going to hear about the plaintiff herself, Ms. Gilmore. She worked at that store for 10 years. For 10 years, she used that loading dock multiple times every week. She never tripped. She never fell. She never complained about any of the conditions. Not until January 23rd. What you're going to hear is that on January 23rd, none of those conditions were any different. The only thing that was different was what the plaintiff did. You'll hear what happened that night. Around 7 p.m., Ms. Gilmore and a coworker open that back door, walk out onto that loading dock. Ms. Gilmore walks down the steps. She smokes a cigarette. She throws away the butt into the dumpster. She goes to walk back up those steps. Those steps she has walked up thousands of times before. And the door is right where it is in this photo. It is straight out across those steps, leaving her just 12 inches to walk around it. You're going to hear, there's no reason the door had to be there. She could have asked the coworker standing in the doorway to close it a little bit, or to open it all the way, to swing it so it was flush against the wall. You'll hear she didn't do either. You'll hear she knew how dark it would be, but she didn't bring a light either. Instead, in the dark, she tried to scoot around that door. She took a step and she missed. She fell. And she got hurt. Folks, what the evidence will show is that those steps, well, they were safe as long as the employees were being safe. Now, it is the plaintiff who has brought a claim of negligence against her former employer, Chimes. It's the plaintiff who has got to prove every element of that claim. I've got to prove to you today that there was an unreasonable risk of harm, that Chimes knew or should have known about that risk, and that Chimes didn't use ordinary care to protect its employees. But the problem with that is that's just not what the evidence is going to tell you today. For starters, you're going to hear that those stairs were as safe as they could possibly be. Ms. Geller is going to tell you what a loading dock is, why you need it. She'll tell you, you simply cannot have a department store without a loading dock. Doesn't work. Doesn't make sense. She's going to tell you, you cannot have a loading dock that has a railing. You can't move stuff from the truck into the store. She'll tell you that railing had to come down. But she'll tell you that in the 14 years since it's come down, not a single employee, certainly not the plaintiff, has ever come to her to tell her that they felt unsafe back there. If they had, she would have done something. Now, you're not just going to hear that those stairs were safe. You're also going to hear testimony from someone who's an expert in this field. That person is going to tell you that even from an expert's opinion, those stairs were safe. Not a thing needed to be changed. There is no doubt that what happened to Ms. Gilmore is awful. We're not going to try to minimize that today. And of course, it is never easy when someone gets hurt to say that their own actions might have been the reason why. But the facts in today's case will require you to do just that. You're going to learn about what Ms. Gilmore did. She knew the risks that were out there on those steps. She didn't bring a light. She didn't close that door. The evidence will show those steps were safe, as long as the employees were safe. So at the end of this trial, I will come before you again. I will remind you of that evidence, and I will ask you to find Chimes not liable. Thank you.
All right. Unless we have other things to take up, I'm ready for the first witness.
Yes, Your Honor. The plaintiff calls Jordan Gilmore.
Ms. Gilmore, have you been sworn?
Yes, Your Honor.
All right. Counsel, you may proceed.
Good afternoon. Please introduce yourself to the jury and tell us what you do for a living.
Hi, my name is Jordan Gilmore. I'm from Waco, Texas. Right now, I'm currently unemployed, but I used to work for Chimes.
Are you married?
I'm not.
You mentioned that you used to work for Chimes. What's Chimes?
Chimes is a local department store here in Waco. They sell clothing and home goods, appliances, that sort of thing.
What type of work did you do at the store?
I was a cashier, so I'd help check people out up front.
And how long did you work for Chimes department store?
About 10 years.
So why'd you leave?
Well, I got hurt and I couldn't work for a while. And by the time that I could go back to work and my doctor cleared me, they didn't have a job for me anymore.
Let's talk more about your injury. Do you remember the events of January 23rd, 2019?
I do.
What do you remember about that day?
Well, I had a shift from 12 to 8 that day. And about 7 o'clock that night, me and Riley went out to take a quick smoke break. And in the process of trying to come back in from that, that's when I fell and hurt myself.
Miss Gilmore, let's rewind a little bit. At around what time were you injured?
About 7.
And what were you doing at the time that you were injured?
I was trying to come back inside the store, so I was walking back up the steps to the loading dock.
I want to walk through exactly how you were injured. You mentioned you were outside by the loading dock. Why were you there?
That's where they made us go smoke. They wouldn't let us go outside the front of the store, so we had to go out back by the dumpster.
You said they made you smoke there. And did your boss ever send out a memo telling you to go smoke there?
Yes. I guess somebody got caught smoking outside and the owner came by or something like that. So we all got a memo that expressly forbid us from going outside the store in the front to go smoke. We had to go out by the dumpster.
So besides a smoke break, or were there other times that you would go into that area?
Yeah, we had to go out there to take the trash out because that's where the dumpster was.
And how often would you say you would go out there to take out the trash?
Once or twice a day.
Your Honor, I have a photograph which has already been entered into evidence as Exhibit 2. It can be found on page 123 of the electronic notebook. Ms. Gilmore, do you have a copy of Exhibit 2 for identification?
I think so. Sorry, I'm trying to find it.
No worries. Mr. Patel, will you please publish Exhibit 2 for the members of the jury?
I found it. I have a copy now. Sorry.
No problem, Ms. Gilmore.
And counsel may pause for just a second and tell you that it might go faster for pre-admitted exhibits for you to just display it for witnesses to see rather than having them look it up in the record. I have no objection to you doing that way if it's easy enough for you. So just for future reference, you don't have to have them exhibit familiarity with it or know anything about it. Just show it to them and ask them the questions. And since it's pre-admitted, that seems fine to me. Any objection to that? All right, you continue, please.
Ms. Gilmore, do you recognize this photograph that we're looking at?
I do.
And what's it a photo of?
This is the loading dock behind the store.
And you mentioned that you exited the doors to come to the loading dock. Were those doors the ones in the middle of the photo?
Yeah, that's right.
And looking at this photograph, where is the loading dock in this photo?
It's that big chunk right underneath the doors, kind of that flat part in the middle.
You said that it was about 7 o'clock when you were injured. Was it still light outside?
No, that time of year it's completely dark by 7.
Are there any lights outside by the loading dock?
There's one there, but it wasn't on. I don't think it's ever been on.
Why isn't it ever on?
I don't know. We don't have a switch for it in our store. For some reason, the light switch is in the Tractor Supply store next door. So we aren't able to turn it on. I've never actually seen it turned on.
Well, did you ever try to tell management that you couldn't turn on the light?
Well, yeah. I mean, we have to go out there to take out the trash, whether it's dark or not. So we've asked about getting the light turned on before.
Thank you, Mr. Patel. Will you please take down Exhibit 2? Now, Ms. Gilmore, was there anyone else with you during your break?
Yeah, Riley went outside with me.
What's the first thing you did when you and Riley went outside?
Oh, well, I went down the steps out to that driveway area in front of the landing, and Riley stayed up on the platform.
Why'd you go down the steps?
I didn't want cigarette smoke to blow back in the store. I didn't want to get in trouble for it.
Did Riley come with you?
No, I thought it was a little rude, but she stayed up on the landing in front of the door. It was super cold and really windy that night, so by standing in front of the door, she was blocking some of the wind.
Could you see the steps as you walked down the loading dock?
Sort of, not real well. It was, well, like I said, it was dark and there were no lights on, but since Riley was holding the door open, there was some light coming out from the back of the store.
Your Honor, I have a photograph which has been pre-admitted as Exhibit 17 for identification. Mr. Patel, will you please share Exhibit 17 for the jury? Thank you. Now, Ms. Gilmore, as you walk down these steps, was there anything for you to hold on to?
Just the side of the building.
How long were you down there for?
Maybe 5 minutes.
What'd you do after that?
Well, I went to come back in.
Were you able to make it into the store?
I wasn't. When I reached the top, the top step, Riley had the door propped open, so I was trying to walk around it, and that's when I fell off the side.
Let's break that down a little bit more. Why were you stepping around the door?
Riley was holding the door open, so it was blocking most of the landing area between the steps and the other side of the door.
Your Honor, I have a photograph which has been pre-admitted as Exhibit 4 for identification. Mr. Patel, will you please post Exhibit 4? Thank you. Ms. Gilmore, is this the door leading to the loading dock?
Yes.
Where were you in relation to the door as you were walking up the steps?
I would have been coming up right behind what you see. So like if I was standing there, you wouldn't be able to see me because the door was in front of me.
And what happened as you tried to step around that door?
Well, I guess I thought I had more space than I did. Because when I went to step up with my right foot, I stepped on nothing out beside that door. And that's when I fell to the ground below.
How'd you land?
Well, I tried to kind of move my body a little to land on both feet. And I did, but the ground's really uneven. So I mostly landed on my right leg. And then afterward, I fell backward onto my butt.
Ms. Gilmore, were you able to walk afterwards?
I was not. I was in excruciating pain.
Do you remember how many stitches you got after that?
28.
Thank you, Mr. Patel. You may take down Exhibit 4. Ms. Gilmore, what type of injuries did you sustain because of this accident?
Well, my knee was completely shattered. Had to have the whole thing replaced, have an artificial knee put in.
Did you ever tell anyone in Chimes management about what happened?
Well, yeah, I mean, right after I fell, Riley helped me back into the store and we reported it to the manager.
How did your manager respond?
She said, yeah, somebody should have fixed those steps a long time ago. She said she'd reported it to the owners, but she guessed they had other things they needed to fix first.
Thank you, Ms. Gilmore. Your Honor, no further questions at this time.
All right, cross-examination.
Yes, Your Honor. Good afternoon, Ms. Gilmore.
Hello.
You worked at Chimes department store for 10 years, is that right?
That's right.
During those 10 years, the dumpster was always located out back behind the building.
It was?
By the loading dock.
Mm-hmm.
During those 10 years, you were always required as part of your job to go throw trash away in that dumpster, right?
Yeah, that's right.
You threw trash away every single shift that you worked.
Probably, yeah.
Sometimes more than once a shift?
Mm-hmm. Sure.
You also smoked the whole time you worked at Chimes.
I did.
You're smoking about a pack a day, is that right?
That's right.
That means you took at least one smoke break every shift that you worked at Chimes.
Yeah, sure.
Sometimes more than one?
Maybe.
Between your smoke breaks and going to throw that trash away, you were out on that loading dock about 20 times a week, right?
Yeah, that's probably right.
Ms. Gilmore, this might sound like a silly question, but you'd agree with me there are 52 weeks in a year.
I would.
Now, by my math, 52 times 20 times a week, that's about 1,000 times per year. Does that sound right to you?
It does.
For 10 years, that's about 10,000 times in total that you went out on that loading dock.
Mm-hmm.
Those 10,000 times, you never slipped, right?
No, not before that night.
Never tripped.
No.
Never fell.
No.
Now, between the first time you went out on that loading dock and the day you fell, nothing significant changed about the lighting, right?
Correct.
Nothing significant changed about the railing.
That's right.
Nothing significant changed about the steps.
Nope.
Nothing significant changed about the door.
No.
For the 10 years that you worked for Chimes, you never told anyone in management that you had a problem with the condition of the stairs.
Probably not. No.
You never told anyone you had a problem with the lack of railing.
No.
Never told anyone you had a problem with the door.
No.
And you told us a few minutes ago that the outdoor light on that loading dock, it usually wasn't on, right?
That's right.
But you knew that before January 23rd.
Sure.
And on January 23rd, when you headed out to the loading dock that night, you didn't bring, say, a flashlight with you.
No.
Ms. Gilmore, you have an iPhone, right?
I do.
That's got a flashlight function on it.
It does.
And even though you were on a work break, you didn't bring your phone with you.
I don't get a lot of calls on my cell phone during work hours, so no, I was only going to be out there for a minute. I didn't take it.
You didn't bring your phone either to answer a call or to use that flashlight function, did you?
Nope.
So the only light you had while you were out there was the light that would come through the open doors. Is that true?
Mm-hmm. Yeah, that's right.
Your coworker Riley was with you.
She was.
She was standing in front of the doors.
Mm-hmm.
You could have asked her to move so that she wasn't blocking any light.
Sure.
You could have asked her to push that door open all the way.
Yeah, I could have. I think that would have defeated the purpose of her standing in front of it.
You could have asked her to do that.
Yeah, sure.
I want to talk about that door a bit more. We're going to publish Exhibit 3, which is already in evidence. This is a photo taken from the top of the loading dock, right?
Yeah.
This is the position that door was in when you walked back up those stairs.
Yeah, it was.
You can see that it's blocking most of the walkway.
Mm-hmm.
Now, instead of trying to walk around that door, you could have asked your coworker to push it all the way open.
Yes.
We're going to publish Exhibit 6, which has already been entered as well. Ms. Gilmore, in this photo, that door is all the way open. Is that right?
Yes.
Basically flush against that outdoor wall.
Mm-hmm.
This is not how that door looked when you tried to enter the building the first time, is it?
No.
Thank you, Ms. Smith. Ms. Gilmore, after you fell, your coworker helped you up, right?
She did.
She helped you up the stairs.
Mm-hmm.
At that point, she opened that door all the way, didn't she?
When what?
When your coworker helped you back into the building after you fell, that door was open all the way, wasn't it?
Maybe. I don't really remember. Probably.
Ms. Gilmore, do you not remember what the position of the door was at the time that you walked back through it after you'd fallen?
No, not really. I was in a lot of pain.
Would looking at your deposition help refresh your recollection?
Probably.
Okay. Give me just a second.
Sure.
Your Honor, at this time, permission to share on my screen, constructively outside the view of the jury, page 12 of this witness's deposition in order to refresh her recollection.
Permitted.
I'm gonna go ahead and do that myself. This is just a portion of your deposition at the bottom of page 12. I'm gonna ask you to read this, Ms. Gilmore, and let me know if this refreshes your recollection.
Starting on line 20?
Sure, you could just read it silently to yourself.
Oh, okay, yeah.
Did that refresh your recollection?
No. You're asking me how open the door was when Riley was helping me go back into the building?
Yes, I am.
Okay. No, I do not recall.
Even after reading this, you do not recall?
This doesn't tell me anything.
Ms. Gilmore, doesn't this say that the door was all the way open and against the wall, just like it was when you actually walked inside?
Oh, okay. Okay, then yeah, I suppose it was open all the way.
So when you walked back inside that building, the door was open all the way?
Apparently.
And you got in fine, didn't you?
I did.
Thank you. Nothing further.
All right, is there any need for Ms. Gilmore to stay?
Yes, Your Honor, a redirect examination.
All right, that'd be fine.
Ms. Gilmore, I want to ask you more about that door that was open the day that you fell. Were there any signs that required you to push that door all the way out when you were going outside for a smoke break?
You mean like a sign on the door?
Any sign that said, please push the door all the way out.
No, not that I recall.
Did the defendant train you to open the door all the way in case something happened?
No, don't believe so.
Thank you, Ms. Gilmore. Your Honor, no further questions for this witness. May she be excused?
Fine with me. Any other questions?
No recross.
All right, Ms. Gilmore, you're excused. Thank you for coming. The plaintiff have any other witnesses?
Yes, Your Honor. Pursuant to the rules of this jurisdiction, the plaintiff would like to call Kelly Danes, who is an unavailable witness and will be called by deposition.
All right.
Your Honor, just so the court is aware, I'll be reading the questions and my co-counsel will be reading the answers. Your Honor, if you'd like, I could share the document from which we will be reading from, or I can just read from it.
Let's try it for a minute, just reading. Let me instruct the members of the jury that Mr. Patel is not Mr. Dane, but Mr. Dane has had a deposition taken in which his sworn answers to questions have been offered. They are considered the same as a live witness. And so when you hear Mr. Patel speak, you're free to consider his answers the same as they were that Mr. Dane gave. And so this will be our best approximation of what a live witness is in the event a witness is not available as Kelly Dane is not. So you may proceed with this.
Yes, Your Honor. I'll be glancing at my second monitor, so I'm not just looking out in the distance. Question.
That's the way the world works now, isn't it?
We love technology.
I know.
Page 2, line 6, question. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Line 12, question, tell us about your education.
I have a Bachelor's of Science in Mechanical Engineering from the University of Wisconsin-Madison.
Since graduating from college with your mechanical engineering degree, have you gotten any further education?
Sure. I've attended various seminars offered by the National Academy of Forensic Engineers. I took the courses to become a certified person builder from the Scaffolding Training Institute, and I took the requisite courses to become certified in ASME B31.3 process piping design from the American Society of Mechanical Engineers. So basically some continuing education and additional certifications.
I noticed that your CV lists you as a PE. What is that?
It stands for Professional Engineer.
What do you do professionally?
I am the president of Danes Engineering, LLC.
What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Over the course of your career, how many incidents have you investigated?
Over 60.
All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took some pictures of the area.
Are exhibits 16 through 21 fair and accurate depictions of how that area looked at the time of Jordan Gilmore's fall?
Yes. Well, it was dark when she fell, but other than that, this is the same area and how it looked.
And what do these pictures show?
Well, as you can see, there are no railings on the steps up to the landing area, and there's no railing on the landing area itself. Plus, you can see where the railing used to go into the concrete and how the concrete around those areas is worn down and cracked. So you can see that this is a pretty dangerous situation.
Moving on to page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and the landing in question, and the facilities in question must be in compliance with those codes and regulations.
All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found at 29 USCS section 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective program. But the defendant didn't have such a program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37b1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37b requires that the lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the Chime store. So there is no way for employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
What's next?
Next, we move on to OSHA 1910.23D1 and 1910.24H and IBC 1009.11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on an exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
I'm showing you what has been marked as Exhibit 34. Do you recognize this?
Yes, that is a photograph of the back of the building taken around the year 2000, back when that entire building was a Walmart and before Chimes was a tenant. And as you can see, there is a guardrail on that set of stairs and railing, so it must have been removed at some point.
Is Exhibit 34 a fair and accurate depiction of the outside of the back of the building as it appeared in the year 2000?
Yes, it is.
Now, any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have been easily avoided by fixed by putting up a guardrail around those stairs and landing and patching the cracked concrete on those steps. It would have been easy. And if the defendant had taken these simple steps, putting a guardrail along those stairs, putting a guardrail around that landing, making sure it was well lit, patching the concrete, then the plaintiff's fall would not have happened.
Your Honor, that concludes our reading of Mr. Dane's deposition.
All right. And just so the members of the jury know, those are not the only questions that were asked, and the lawyers are allowed to select questions that they believe will be helpful in presenting their parts of the case. So we now give the defendant an opportunity to take that same deposition and offer questions and answers from it that have not been previously offered. So does the defense have anything out of Mr. Dane's deposition you wish to offer?
We do, Your Honor. And can my co-counsel help me in showing this to the jury?
Yes, this is a new Mr. Dane. But by the same token, all we're doing is presenting those answers instead of reading a book to you, having live people do it. So this is considered more efficient and easier to listen to. So pay no attention to the fact that the identity of the person may look different. We're trying to listen to what the witness, Mr. Dane, had to say. So you can select that part of the deposition you'd wish to offer.
Thank you. Mr. Dane, I'm going to start on page 14 at line 12 through line 21. You would agree, though, that this area was used by Chimes as a loading dock at times?
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock.
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
Thank you. Nothing further from this witness.
All right. Is there anything else to offer from Kelly Dane's deposition testimony?
No, Your Honor. With that, the plaintiff rests.
All right. Ladies and gentlemen of the jury, when the plaintiff rests, that means that the defendant will now have an opportunity to present witnesses or other evidence that they wish to offer. I'm going to give the parties 2 minutes to get a drink of water. The same is true for members of the jury. If you'd like to take a short break and get some water or something like that, it'll be 2 minutes. And so, take 2 minutes. When my picture shows up on the screen again, it's time to start. How's that? All right, 2 minutes. Could all our jurors confirm for me that you are here and ready to proceed? Okay. Okay, I've got everybody here. So we're ready for the defense. If they care to present anything, anything for the defense.
Yes, Your Honor, but before we call any witnesses, we'd like to request a sidebar to revisit one of the motions in limine.
Fine.
Assuming we're now in that constructive sidebar, this concerns the plaintiff's motion about excluding any testimony from Perry Hayden that he inspected chimes before the accident and found no OSHA violations. If I can be heard on this point.
I'm ready.
Plaintiff, as I understand plaintiff counsel's objection to this testimony, it's that it's more prejudicial than probative. Now, the bar there is that it would have to be substantially more prejudicial than probative. That's extremely hard to do, especially in this case, because this testimony is so probative. The testimony that an OSHA inspector, someone whose job it was to tell you whether or not a workplace is safe, visited this workplace and said it was safe, goes right to the heart of the issue in today's case. And further, plaintiff's counsel actually cited OSHA regulations when they read onto the record portions of Kelly Dane's, their own experts, deposition. And so they've opened the door to more testimony about OSHA violations and just another person's opinion about whether or not that those conditions constituted a violation of those rules.
All right. Response?
Your Honor, the issue with that testimony is the fact that Your Honor's jury charge actually states that this case is a negligence standard. It is not any standard that is given by OSHA. And therefore, it is substantially more prejudicial than probative for the members of the jury to hear that there was some other standard that was used when they're supposed to focus on negligence. Now, negligence in and of itself to a layperson is difficult to understand. And when you add in the layer of the OSHA violation, it will mislead the jury into believing that the defendant was not negligent and therefore will interfere with Your Honor's jury charge.
Your Honor,
Okay.
Can I respond briefly?
Yeah, let me tell you what I heard from Mr. Dane, and that was that he said that the area was in clear violation of OSHA regulations. Is there any dispute about whether he said that?
Your Honor, the witness did list the IBC codes as well as the OSHA codes. However, the witness did not talk about what standard is required to actually issue an OSHA citation.
All right. Response from or rebuttal from the defendant. I've forgotten exactly how those words go. So your turn.
Yes, Your Honor. If plaintiff's counsel was concerned that offering OSHA standards was going to confuse the jury, then they shouldn't have offered OSHA standards with their own expert moments ago. What they're trying to do now after opening the door is unfairly close the door on me to prevent the defense from offering the same type of evidence that they just offered. That's just unfair.
All right. You may ask questions or elicit evidence about the OSHA inspection and results of that inspection. So my motion in limine is withdrawn at this, the order in limine is withdrawn.
Understood. And just to maintain a little suspense, Your Honor, we're actually going to wait on that, and we're first going to call Reese Geller to the stand.
Yeah, I'm breathless.
I hope so.
So this is the defense witness. I'm sorry, say one more time. Name of the witness?
Reese Geller.
All right, thank you. You may inquire.
Thank you. Good afternoon, Ms. Geller.
Good afternoon.
Can you tell us a little bit about yourself?
My name is Reese Geller. I'm 45 years old and I live here in Waco, Texas with my husband and my 3 kids. I went to Baylor and I graduated in 1998 with a business degree. I've worked for Chimes for my entire career. It's our family business.
You said Chimes is the family business. What business is that exactly?
So it's a department store here in Waco. We sell a little bit of everything, from clothes to tools, kind of everything in between. And my grandparents started it years ago, and my parents took it over from them, and then I took it over from my parents.
How long ago did you take over?
About 10 years ago.
Now, where is Chimes?
Chimes is over on Bosque Boulevard. That's right across town here in Waco.
I want to talk a little bit about the layout of the store. Can you describe it in general terms?
Sure. So Chimes is in a shopping center. It's in the middle of the shopping center. We also lease the parking lot right out front for our customers, and there's a loading dock in the back.
I want to talk about that loading dock. We're going to publish Exhibit 19, which has already been entered. What is this?
That's the loading dock I was talking about.
Now, what is a loading dock?
So a loading dock is where we receive all of our deliveries for the store, all of our merchandise. It's a platform so that trucks can back up and lower their door and then safely unload merchandise from the truck onto the loading dock and into the store.
Ms. Geller, is it possible to run a department store without a loading dock?
I imagine it would be very difficult, and I don't want to try.
Well, is it possible to have a loading dock that has a railing around it?
No, definitely not. That wouldn't be safe for the truck drivers or for our employees. They have to lift merchandise over their heads and lift it over that railing to get it into the store.
When you first moved into this building, was there a railing around this loading dock?
There was. It hadn't been used as a loading dock in the past.
What did you do when you first moved in?
We asked the landlord to remove it as part of our lease negotiation.
Did the landlord remove it?
They did.
Other than using this area for a loading dock, what else do you use it for?
Our employees take smoke breaks out there occasionally. We also have the dumpster out there, as you can see. So whenever we have trash from the store, that's where we put it.
How do you expect your employees to act when they're out on this loading dock or in this area?
Well, I mean, I hope they would proceed with safety and caution, but you know, they just act like they're on break and don't go crazy.
When you say you hope they proceed with safety and caution, what do you mean by that?
You know, just looking out for their surroundings generally, as you would wherever you go.
I want to ask you a few more questions about this back area, specifically the lighting. Are employees ever in this area when it's dark outside?
Sometimes.
And what is the lighting like in this area?
There's a light above the loading dock, but the switch for it was in the other unit next door.
Was there any other way to get light out in this area?
If the doors are open to the loading dock, then the light from inside shines out there, and then employees can use their phones as flashlights or whatever to get down the steps safely.
Thank you, Ms. Smith. I want to talk about whether you'd ever had any issues with that loading dock before. How often do you receive deliveries there?
Every day, sometimes multiple times a day.
So if you receive deliveries every day, employees are also out there for smoke breaks and to take out trash. How often do the employees go out there?
Multiple times a day, especially if they're a smoker.
Have you been in this courtroom for all of this trial today?
I have.
Did you hear Ms. Gilmore say that she'd been out there about 10,000 times?
I did. I was impressed by that number.
How long have you been using that back area as a loading dock?
Ever since our store moved there in 2005.
So 2005 to now, that's about 16 years. Is that right?
That's right.
In those 16 years, how many issues have you ever had with anyone getting hurt out there?
Before Miss Gilmore's accident, it was just one other issue.
Ms. Geller, is your store regularly inspected by OSHA for any workplace safety issues?
Yes, they routinely inspect.
When was the store last inspected before January 23rd of 2019?
We had an inspection done in 2018, so less than a year before that date.
Less than a year before that accident, in that OSHA inspection, did you receive any citations?
No, we didn't.
Were you given notice of anything around the premises that you needed to change?
No.
Ms. Geller, during the entire tenure of Ms. Gilmore's employment for Chimes, did she ever once report any safety issues that you're aware of?
No, not that I'm aware of.
Thank you. Pass the witness.
May I proceed, Your Honor?
Cross-examination.
Ms. Geller, you're here testifying as the owner of Chimes Department Store.
That's correct.
You've owned the store for 10 years now.
That's right.
In your own words, you claim that you worked your way up, right?
That's right. I started in merchandising and I worked my way up from there.
But as you mentioned on direct examination, the company was actually started by your grandparents.
That's right. They made me work hard for it.
And then handed down to your parents.
Yes.
Who later turned it over to you.
That's correct.
So basically, you worked your way to the top of a family business, right?
That's right.
Now, today you're denying any responsibility for the injury suffered by Miss Gilmore.
That's correct.
While she was working at your store.
Yes.
You believe that Miss Gilmore should be held accountable.
I believe that it's not up to us to be held accountable.
You consider her choices bad choices.
I don't think she was being safe, no.
Now, you admit that you don't regularly inspect the area around your store to look for safety issues.
No, not regularly.
Because you claim you're not a safety company.
We're a department store.
That's right. In your own words, you call yourself a department store instead of a safety company.
I think that's an accurate description.
So instead, you just instruct your employees to look out for safety issues.
I mean, a lot of our employees have been working with us for a long time, so they do know to look out for safety issues on the job.
That's right. According to you, that's part of their job.
I mean, I think that's a part of any job would be to look out for where you're going.
And you consider that part of your employee's job, right?
Of course.
And you expect them to alert you if they see anything that should worry them.
Of course, that's just common sense.
But the area that they alerted you about was your rear loading dock that you were talking about on direct.
I don't recall what alert you're referring to.
Well, you believe that you have no duty to make it safe, right?
I'm not sure what you mean by that.
Let's say your employees alerted you about your rear loading dock in the back, okay?
Hypothetically?
Hypothetically.
Okay.
You believe you have no duty to make it safe.
I don't know what you mean by duty, but I think that if they told me something, then I would check into it.
Well, if they brought it to your attention, you would think that it was up to them to stay safe, right?
Right.
You admit that you use the area pretty often.
Every day.
On a daily basis.
Right.
As a loading dock.
Yes.
That means that companies would bring you supplies, right?
Right, and merchandise for our store.
It's a place where you required employees to go for smoking breaks.
They can go wherever they would like to, as long as it's not in front of the store. But they routinely went back out there.
And that's also the location for your dumpster, right?
That's right.
And you're the one who ordered that dumpster.
Yes, we needed somewhere to put our trash.
And you require your employees to clean that area.
I just want to make sure that they don't leave any, debris around the dumpster.
Right. And you're not aware of anybody else that's ever cleaned that area, right?
Not that I'm aware of. Other people could certainly use that area if they'd like to, but.
Can we stop for a minute? I think I may have a technical problem with one of the other people. Can we stop for just a second?
Absolutely, Your Honor.
All right, make a mark where you are. Okay, we're okay now. I'm sorry.
No worries, Your Honor. Is everything okay?
We've got everybody back on.
Perfect. Now, let's talk a little bit more about the location that you chose for your store. Referring court and counsel to what's been pre-marked as Exhibit 13 for identification. That can be found in the electronic notebook, Your Honor. And Ms. Geller, do you have a copy of that document?
Not readily available, but I can pull one up.
Your Honor, may I constructively share the document for the witness?
You may.
Mr. Patel, will you please post Exhibit 13 constructively?
I can look forward if that's faster.
Here it comes.
Thank you, Mr. Patel.
I can see it. Is anybody unable to see it that needs to? You may proceed, counsel.
Now, in this email, you asked Kermit Realty to remove the railings from the steps and landing area behind your store, right?
That's right.
Kermit Realty is the entity from which you rented the property.
They're our landlord. That's right.
And you wanted to use that area as a loading dock.
Yes.
You agreed to pay the cost to make the change.
Yes, that's true.
And ultimately, your landlord made that change.
That's true.
And then they reimbursed you for it, right?
Yeah, I don't recall. I believe so.
Thank you, Mr. Patel. You may take down Exhibit 13. Ms. Geller, you're aware that Jordan Gilmore isn't the first person to be injured in the area of the loading dock.
No, we had an incident in 2010.
That's right. 9 years before, an employee actually fell out on the loading dock.
That's right.
And you reviewed the statement given by that employee about his fall.
Yes, I did.
And he was taking out the trash.
He was.
As part of his job duties.
Right.
And the light behind the store, it wasn't on.
I don't recall that.
Well, you do recall that when he asked his supervisor where the switch was, he was told the only switch was in the store next door.
That's true.
So there was nothing she could do about it.
That's true.
You're aware that he slipped on loose concrete that night.
Yes.
Had no rails to hold on to.
That's right.
He fell face down to the bottom of the steps.
Right.
And when your employee was asked what steps could be taken to prevent such future injuries, in that document, they said, make sure there's adequate lighting on the loading dock.
Right. And as per the terms of our lease, that's up to the landlord to provide.
That's a repair that you think you shouldn't be the one to make.
Correct.
No further questions, Your Honor.
All right. Any redirect?
No redirect, Your Honor. Can Ms. Geller be excused?
Ms. Geller may be excused. Thank you for coming. All right. Do you have any other witnesses?
Yes. Defense calls by deposition Perry Hayden.
All right. Are we using the same procedure that we used with the prior deposition?
That's
all right.
Right.
So members of the jury, you'll be reminded that this is not the witness. This is an assistant to defense counsel who is going to read the answers, and defense counsel going to read the questions, right?
That's right.
And so you may consider this the same testimony that the witness would have given had they been able to appear live, but we have determined they are not able to appear live. All right, so you can make your selection and offer your testimony that you want to from this witness.
Starting on page 2, lines 5 through 23. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
How old are you?
I'm 35 years old.
Where do you live?
I live in Austin, Texas.
What do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is the government agency that is responsible for making sure that workplaces are safe for the employees that work there. So we provide information, training, and assistance to employees and employers to make workplaces as safe as possible and to make sure those workplaces are in compliance with OSHA regulations and standards. We're all about employee safety.
And what do you do at OSHA as a compliance, safety, and health officer?
I am one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
Skipping to page 3, lines 16 through 24. How long have you worked for OSHA?
Since I got out of school. So at this point, that's about 13 years.
And over that time, how many inspections have you conducted?
Oh man, hundreds? Thousands? I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
What kind of education did you receive before becoming an inspector for OSHA?
I graduated from high school and then I went to Texas State Technical College where I got an associate's degree in occupational safety compliance technology. Then I went on and got a second associate's degree in environmental technology compliance.
What are those degrees about?
Well, these are really training programs dealing with the hazards of machines, safe work methods, environmental hazards, workplace hazards, and various safety issues. These are literally the degrees you need if you want to do something like work for OSHA. That's why I got them, because I figured working for OSHA would be a good, steady job.
At this time, defense offers Perry Hayden as an expert in OSHA regulation compliance.
Response, plaintiff, comments?
Your Honor, I believe per the stipulations, the objections have been waived.
Okay. You may proceed.
Thank you, Your Honor. We're going to carry on starting on page 5, lines 6 through 8. All right, Ms. Hayden, how are you involved in this case?
Well, I conducted an inspection at that Chimes department store in Waco back in 2018. So I assume that's why I'm here.
Moving to page 5, line 20. So were there any complaints that led to this inspection?
Not that I'm aware of. I went out there because it had been a while since we'd been there. That's it.
During the inspection, what were you looking for?
At the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
Moving to page 6, lines 11 through 13. Did you inspect the area behind the store where there is a little landing area and some steps?
Yes, I did.
Moving to page 6, lines 8 through 10. Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Thank you. Pass the witness.
All right. The plaintiff wish to offer anything from this deposition?
Yes, Your Honor.
Okay, so same thing has happened last time. The witness looks different, but it's still the same witness and the same credit or evaluations to be made of this testimony as though the witness were here live.
May I proceed?
You may.
Starting on page 6, line 11. Did you inspect the area behind the store where there is a little landing area and some steps?
Yes, I did.
Why did you inspect that area?
At the beginning of every inspection, I asked the representative for the employer to outline for me all of the areas where their employees work. When I asked that question to the manager at Chimes that day, they told me that the employees regularly worked in that area behind the store and took smoke breaks there. So once I had that information, I made sure to include it on my list of areas to inspect.
On page 7, line 1, I apologize, page 6, line 22. When you went out there, did you notice anything about the steps and that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and the landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
Moving on to page 10, line 5. Question. Do you disagree with the assessment of your boss in this email?
No, I don't. I'm fairly conservative when it comes to issuing citations. Look, I obviously believe that workplaces need to be safe for employees, but that doesn't mean the government should be draconian in enforcing those regulations, especially in times like these when it's hard enough to find a job or a place to work. So maybe I'm a little bit more lenient than other inspectors. That's certainly possible. But I do my job and I do it well. And we talked about the issue and it was all good. It's not like I've been fired or anything.
Moving on to page 11, question 16. Line 16, I apologize. Question, did you ever inspect that area behind the store at night?
No, only during the daytime.
Line 23, question, and what did the manager say?
The manager told me that they always turn the light on when someone goes out at night. So that seemed good enough for me.
Your Honor, that concludes the reading of this witness's deposition for the plaintiff.
All right. Anything else from this deposition we need to offer or hear?
Nothing else from the defendant.
All right. Does the defendant have any further witnesses or evidence to offer?
No, Your Honor. At this time, we rest our case in chief.
All right, ladies and gentlemen of the jury, that means that the evidence has been concluded. I will give you a few moments because we're going to have a constructive discussion now that the case has ended, or we'll determine whether we have any more to do. We'll be right back with y'all, so stay to the side and I will speak to counsel now. For the plaintiff, do you have any rebuttal evidence you wish to offer, or is there anything else left to do?
No, Your Honor. Plaintiff is ready for closing arguments.
All right. And for the defense, anything we need to take up before closing?
Nothing to take up before closing.
All right. And this is just curiosity from the bench's part. What is the jury charge you will be arguing?
Your Honor, the defendant has chosen the second jury charge.
Okay. All right. That just helps me. So yeah, I was just curious.
Absolutely.
All right, so what I have now, and y'all can help me or let me know if I'm off on this. I have the plaintiff with a little bit over 21 minutes left. Is that consistent with your timekeeping?
That's consistent with our timekeeping, Your Honor.
Okay, and I have the defendant with a little more like 27 minutes left. Is that consistent with your timekeeping?
That sounds about right.
Okay, and is that sufficient time for both of you, please?
That's certainly plenty for us.
Yes, Your Honor.
Okay, very good. I'm assuming that you will want to divide this up. Do you need anybody to give you any signals about how much time you have taken or how much you'll have left?
I just request that my co-counsel give me the signals once I reach, the danger zone time.
Okay, as long as you have to work out, I just need to know if you needed my help. So no from the plaintiff. Do you need any help?
I do not anticipate getting close to 27 minutes, which I'm sure Your
enough.
Honor will be happy to hear.
Yeah, if you get there, I will let you know. All right. So we're prepared to start with closing argument, or do you need 2 or 3 minutes to get your thoughts together or outlines or anything?
It's up to Your Honor. If the members of the jury need the break, we are open to taking the break.
All right. Why don't we all go get a drink of water since we're not pressing up against time really badly. Let's take 3 minutes, go get a drink of water and whatever else you'd like to do. When my camera comes back on, that means 3 minutes have passed. Is that all right? Very good. Thank you. All right, can I get the members of the jury to check in to let me know that they're back? All right. Counsel, are y'all ready to go? All right, very good. Ready. I'm ready to hear from the plaintiff.
May I proceed?
You may.
The defendant had no problem taking risks with the safety of their employees. Make them walk up and down cracked jagged steps to throw away trash every day. No problem. Require them to go up and down those dangerous stairs without any railing to hold on to. No problem. Force them to go out into an area to take their breaks in total darkness. No problem. But when the inevitable happened, and those risks led to a devastating injury for Jordan Gilmore, all of a sudden, it's a problem. But not their problem, members of the jury. Because despite risking employees' safety every single day, they now refuse to take responsibility for their dangerous actions and actually try to shift the blame on Miss Gilmore herself, the person they put at risk. Today, you have the opportunity to finally make the defendant take responsibility for their risky and dangerous choices. As Judge White will instruct you, we had the burden to prove that it's just more likely than not that the defendant was negligent and that negligence caused Miss Gilmore's injuries. Well, today that burden has been met because the evidence has proven three things. First, the defendant knew their loading dock was dangerous. Second, the defendant did nothing to fix that dangerous situation. And third, it was the defendant's negligence that caused Miss Gilmore's injury. So let's take a look at that first thing the evidence showed, that the defendant knew the dock was dangerous. Now, the judge will instruct you that negligence means the failure to use ordinary care or failing to do what a reasonable employer would have done under the same circumstances. So how can you be sure that the defendant failed to use ordinary care? Well, you heard straight from their own defendant, who told you that they had been in the same location for 16 years. In fact, she knew very well that there was no outdoor light for the lighting dock, and that the only way to turn it on was through the other store. And Ms. Gilmore testified that she even complained about this to manager Lane Kim, who even admitted that she tried talking to the defendant a few times and then apologized because there was nothing they could do about it. And then on top of that, you heard that the stairs that the defendant has on that loading dock needed railings. And the same manager that had told Miss Gilmore that they couldn't do anything about it, well, that same manager knew that those steps should have been fixed a long time ago. But how can you be sure that the defendant knew about this issue? Well, you don't have to look further than that prior incident you heard about from 2010. Remember when I cross-examined Miss Geller, and she admitted that she was very well aware of the fact that somebody else had tripped on those stairs in the same way. It was dark out. The person couldn't see. They were going out to throw away the trash. Members of the jury, remember that throwing out the trash and those smoke breaks, those were all the activities that the defendant chose to send to that area of their warehouse, including the fact that they got materials shipped to them from there. And so what would a reasonable employer have done after that initial incident? Of course, a reasonable employer would have immediately put a stop to it. They would have said, no, this is the first one and the last one, we're done. But the defendant didn't do that. And so that brings me to the second thing the evidence showed, that the defendant did nothing to fix that dangerous condition. Today, the defense called Perry Hayden, who tried to tell you that the loading docks didn't need to have guardrails because they're exempt from all the codes you heard. But members of the jury, remember, Perry Hayden is pro-business. You heard how his boss had called him out on the citations that he was making. In fact, when he went to the site of the defendant's shop, even Perry Hayden admitted he was pretty alarmed and saw some pretty obvious issues. Yet, as an OSHA expert, he never tried to verify if that light worked outside. He ignored those cracked steps. And on top of that, he didn't even try to go back and recheck the area at night. And Ms. Geller said something interesting on cross-examination. I wrote it down so that I could get it right. She said, if they told me something, I would have looked into it. Members of the jury, you heard how many times employees complained about various things. When was she going to look into it? Unfortunately, for Ms. Gilmore, that didn't come soon enough. And so that brings me to the third thing the evidence has shown, that it was the defendant's negligence that caused the plaintiff's injury. Members of the jury, the judge will tell you that we had to prove that the defendant was the proximate cause of Ms. Gilmore's injuries, that it would have been reasonably foreseeable to someone that Ms. Gilmore would suffer those injuries. You heard she got 28 stitches on her leg. Imagine what type of a fall can lead to that degree of injury. In fact, you heard from our expert witness, Kelly Danes, who's been in the field for years. Kelly Danes, a mechanical engineer, and specializes in making sure that industrial areas like this one, the backs of shops, that they all follow the proper protocols. And Mr. Danes told you that the defendant violated the IBC and OSHA codes because, first of all, they didn't have a switch for that light outside the defendant's store. Think about it. Who needs a light up there if no one can actually turn the light on when they need to go outside? And on top of that, members of the jury, remember that those codes required guardrails around stairs. So the defendant can spend all their time talking about how this was a loading dock and how loading docks, well, they didn't require people to actually have guardrails because it ruins the purpose. What about the stairs? Think about it. If Miss Gilmore had that railing to hold on to as she went around that door, don't you think that she would have had a better chance of not falling? But no, the defendant still tried to push this off of them. And remember, as much as the defendant tries to push on you that this was just a dock, we needed it, it was so important for us, they knew very well that they used it for other reasons as well. So how many times, those 10,000 times, how many times were they going to risk Miss Gilmore going out there? It was inevitable that she was going to get injured. They could have easily fixed this dangerous situation, but they chose not to. They could have patched that concrete back up. They could have made sure that the area was well lit. If the defendant had done all of that, we wouldn't even be in this courtroom today. Now, members of the jury, in a moment, the judge is going to give you this jury charge. And you'll see that it asks you one question. Did the negligence of any of those named below proximately cause the occurrence or injury in question? And you see that typo, it says if any, it should be of any. Well, members of the jury, based on the evidence that you heard today, you know that you must write yes next to Chimes department stores because it was the defendant and only the defendant who could have stopped this from happening. Members of the jury, how could Jordan Gilmore have known? Why are they putting the blame on Jordan Gilmore? That's because they have run out of excuses. You know she's not the one that caused her own injuries. So we ask you to write no next to her name. Members of the jury, in a moment, the defendant is going to have a chance to speak to you. And when they get up here, listen carefully to what they tell you. Because what you'll hear is that they're going to give you another group of excuses for why they couldn't have made simple changes that would have prevented these injuries from happening. They decided to take a bet on the safety of their employees. And they lost that bet. Find the defendant liable.
Defense care to give a closing argument?
I do, Your Honor. I'm going to take just one moment to adjust my camera.
Fine.
The steps were safe if the employees were safe. Today you heard about that loading dock. The loading dock out back behind Chimes department store. The loading dock that has looked the exact same ever since 2005. 16 years. Employees walking up and down those stairs day after day after day. Not until January 3rd, 2019, did Jordan Gilmore have any issues with those stairs. She spent 10 years going up and down those stairs, 20 times a week, thousands of times a year, 10,000 times in total at least. On January 23rd, 2019, Ms. Gilmore told you nothing about those stairs was different. Nothing about that loading dock was different. The evidence showed the only thing that was different was Ms. Gilmore. It was what she did. You heard that day she knew it would be dark. She didn't bring a light. You heard that day she was walking up the stairs, the door covering the walkway. She didn't move it. She tried to go around it. And she fell. But the evidence showed that those steps were safe when those employees were safe. Now, folks, that is not what the plaintiff would have you believe. The plaintiff today has brought a claim of negligence against Chimes department store. Now, because it's the plaintiff who brought that claim, it is the plaintiff who's got to prove it up. They have what's called the burden of proof. They had to prove every single one of the elements of negligence was more likely than not to be true. Let's talk about those elements together. Number one, they had to show that the conditions that Chimes created caused an unreasonable risk of harm. Number two, they had to show that Chimes knew or should have known of that danger. And number three, they had to show that Chimes failed to use ordinary care to protect employees. Members of the jury, if you find that a single one of these elements was not proved to be more likely than not proved to be true by the greater weight of the credible evidence, well, then you cannot find Chimes liable. So let's walk through these elements. Let's talk about them together. And we're going to start with number one. Did the plaintiff show that the defendant created an unreasonable risk of harm? Unreasonable. That's important. And I want you to hold on to that. It's not any risk of harm. Folks, you know yourself, anytime you walk down any set of stairs, if you're not paying attention, you might get hurt. Everything in life comes with harm, or comes with risk, excuse me. Every time you get in your car to go somewhere, there's a risk. So we're not concerned today with whether there was any risk. We're concerned with whether there was an unreasonable risk, whether there was a risk that wasn't outweighed by the benefits of whatever that design was. So what were the benefits of this loading dock in this case? Well, I want you to think back to when I had Ms. Geller on the stand, the owner of this family business, third generation, located right here in Waco. Ms. Geller told you why you need a loading dock. I asked her, well, can you run a department store without a loading dock? She said, I don't even want to try. I asked her, can you have a loading dock that's got railings around it? She said, no. Not only did she say that having railings around a loading dock would make it difficult to bring inventory in and out of that store, which is essential to their business. Folks, you will remember that she said it might even be more dangerous for their employees to have to carry things over that railing than to have no railing at all. And folks, that's exactly why we have this law. We have a law that Mr. Hayden, that OSHA inspector that you heard him talk about today, or at least through deposition. We have a law that says that guards are not required on the loading side of loading docks. Because folks, it just doesn't make sense to require that. It's just not reasonable to require that. You'll remember that even the plaintiff's expert, Mr. Daines, said he's not aware of any single regulation requiring railings around loading docks. Because folks, it just doesn't make sense to have them. So that first element, whether there was an unreasonable risk of harm, well, there just wasn't. Because you can't have a department store without a loading dock. You can't have a loading dock without a railing. If Ms. Gilmore tries to tell you today that she doesn't want a railing there, well, then Ms. Gilmore is going to be out of a job. That's how you know the plaintiff didn't meet their burden on that first point. And what that means, folks, is that this case is done. Show's over. They had to prove every one of those elements, and they didn't. But just in case there is any lingering question, any lingering doubt in your mind, let's talk about the second element. The plaintiff had to prove to you that the defendant knew or should have known about the danger. Well, who better to ask than the defendant's owner, Reese Geller? When she was on the stand, I asked her what she knew. She said not a single employee, certainly not Jordan Gilmore, ever told her about any issues they had in that back loading dock. Folks, if Ms. Gilmore had a problem, well, Reese Geller can't address a problem she doesn't know about. Ms. Geller told you 16 years, day after day, tens of thousands of trips. Not a single complaint. You'll remember it wasn't just the employees who didn't tell Ms. Geller that there were issues. She actually had someone affirmatively tell her that there weren't issues. She had an expert affirmatively tell her that. Think back to that OSHA inspector, Perry Hayden, that inspector who came to visit Chimes in person, who looked at that loading dock. You'll remember that in his deposition, he said, sure, I looked at the loading dock at first, and I thought, well, maybe this ought to have a rope. I looked at the landing at first, and I thought, maybe this ought to have a railing. But then he said, then I heard it was used as a loading dock. And then I realized the OSHA regulations don't apply. And so that OSHA inspector turns around, writes basically a clean bill of health for Ms. Geller. Says there is nothing you need to change. You're doing everything the best way that you can do, given the circumstances. Those steps were as safe as they could be. The plaintiff had to prove to you that the defendant knew or should have known of the risk, but they just didn't do that. Now we could move on to that third element, whether or not the plaintiff used ordinary care to guard against that risk. But because there was no unreasonable risk, folks, there's no point. But there is someone else in today's case who you need to consider, whose actions you need to consider. And that's Ms. Gilmore. I want to be clear about this. What happened to Ms. Gilmore is awful. We are not trying to minimize that in any way. And of course, when someone gets hurt, it always feels awful to say that their own actions might have been the cause. But folks, we have no choice but to do that here. We have no choice but to do that because you heard about the circumstances. You heard that Jordan Gilmore had been out onto those stairs, knew they didn't have a railing, knew there wouldn't be a light out there. She had been out there not just dozens of times, not just hundreds of times, but 10,000 times at least. She goes out on January 23rd. She knows exactly what to expect. The plaintiff wants to talk about risk. She knew exactly what the risks were. And in those circumstances, knowing what she knew, she chose to walk up those stairs in the dark. And that door, it was completely out, blocking the walkway, blocking the light from inside the building. There was a coworker standing right there, you heard. Someone she could have asked to push the door open further so it wasn't in her way, so she could see the stairs. She could have walked up those stairs like this. Nothing in her path. Light spilling onto those steps. But instead, she walked up those stairs like this, leaving herself just a foot of room to try to navigate around in the dark. Folks, everyone makes mistakes. That's a simple fact of life. But the question we are here today to answer is, who is responsible for what happened? And if a party has made a mistake, well, they've got to be held responsible for their part in making it happen. And the plaintiff, they want to talk about risk and responsibility, and that's fine. But it means we have to talk about Ms. Gilmore's responsibility too. Her responsibility to use ordinary care. We're not asking her to be perfect, but we're not asking the defendant to be perfect either. That's not what the law requires. Folks, sure, you could have a railing on every surface in your home. Chimes could have bubble wrapped that doorway, bubble wrapped that loading dock. But they didn't, because that just doesn't make sense. Because we expect people to use ordinary care. The evidence showed that those steps were safe if the employees were safe. Now, when you go back to deliberate, you're going to get a verdict form. It's going to ask you this question: whose negligence caused the occurrence or injury in question? Because you heard that those steps were safe, you can mark no for Chimes. Because you heard that Ms. Gilmore wasn't, you can mark yes. Simple as that. If the employees were careful, those steps wouldn't have been dangerous. Chimes wasn't negligent. Find them not liable. Thank you.
I believe you're muted, Your Honor. No problem.
But you knew what I said.
I do know what you said. Thank you.
Are you ready to give rebuttal?
Yes, Your Honor.
You may proceed.
Members of the jury, just as I had predicted, the defense came up here and they continued to give you excuse after excuse after excuse. First, they tried to tell you that in 16 years, there hadn't been anything that had gone wrong at the defendant's store. But members of the jury, we all know that all it takes is one time for tragedy to occur. But I guess in the defendant's case, all it takes is twice for them to finally be held accountable for their poor choices. Don't forget the fact that there had been somebody injured in the same way, just like Miss Gilmore in 2010. And they tried to tell you that this wasn't an unreasonable decision for an employer to make, that it was fine, that they didn't fix those steps. But members of the jury, think about it. When employee after employee after employee is complaining about these issues, when you already had an example of one falling down the steps, don't you think to yourself, maybe this is a problem? And so now suddenly the defendant claims that they can't remember the complaints that their own manager had received from various employees regarding the plethora of issues that surrounded those stairs. Then they finally tried one more time to blame the actions of Miss Gilmore. But she's not the one who chose to send employees in the back in a dark area for their smoke breaks. She's not the one who chose to leave those concretes crooked. She's not the one who chose not to fix those steps. She's certainly not the one who chose to leave that door so wide that it blocked the area where employees were supposed to walk through. You know who made that choice. And members of the jury, now it's time for you to make your choice. Those stairs were unsuitable, they were unstable, and the employees were certainly unsafe. Find the defendant liable. Thank you.
All right. That concludes our case. I guess that everybody can turn on their camera. I think that we will have our ballots turned in, and then we'll have some time here for our jurors / judges to make some brief comments, if that would be helpful. I'm wondering if I can just ask the jurors, do y'all need a few minutes to finish with your ballot and turn it in, or?
Just a few.
All right, so let's come back in 2 minutes. How's that?
Thank you.
When my camera comes back on, that means that we will come back. All right.
Sounds good.
Very good. Have all of our jurors gotten their paperwork in?
I've turned mine in.
Thank you.
Yes, Judge.
Okay. Counsel, there's an opportunity now for you to hear comments from these very wise jurors that heard your case. You can decline if you don't want to hear from them. And my instructions to them are very brief. We can't catalog 15 different suggestions from each of you and improve ourselves. But if you have one really important suggestion that could help them do better, I'm sure they'd be glad to hear that. So let's just start. Mr. Cole, what do you got?
Guys, I did this in law school. I'm amazed at what you did. I'm amazed. I never had you get the packet the night before, and you two are going to make excellent lawyers. I have no comments other than that. Great job.
Right. Mr. Hatchett, I'm going by the way my screen is arranged, not by any other order.
Thanks, Judge. My name is James Hatchett. I'm a trial attorney at Howry Breen in Austin. And about 10 years ago, I did the same mock trial stuff that y'all are doing right now. So I understand the preparation that goes into this. For Ms. Forster first, I think sometimes you need to watch out for overselling portions of your case where you don't need to. The thing that made my ears perk up a little bit, because I did around this morning, is you said in your opening statement, those steps were as safe as they possibly could be. I don't know if you remember saying it that way. That's the way it came out. I think everybody knows that they weren't as safe as they possibly could be, but you don't need to meet that standard. I think everybody, and this applies across the board, don't set yourself up for a burden that you don't need to meet, because it could come around to bite you later on. So that's something to keep in mind. I'm going to butcher this, Sahakian, close enough.
You got it. You got it.
Not bad.
So two things. You ended up doing this in your closing argument, but it could have come out a little bit earlier. So the theme of their case, the theme of the defendant's case, the way they set it up, is that they basically were foisting all of the responsibility for keeping the employee safe onto the employee. You obviously, or probably, would not have known that before you came into the round. But I think one of the hallmarks of a great advocate is somebody who can transition and kind of like a judo flip, take that and turn it back around on the other side. So the opportunity there is saying that position completely abdicates any responsibility that the employer has. Like they're saying, we have no responsibility. And you did start saying that during closing argument. I think you could have maybe started to use it a little bit earlier. The other thing too is, and I just noticed it because it came up during evidentiary points, right at the end of Ms. Geller's cross-examination, she tried to say she didn't have the responsibility to do anything about the lighting because it was the landlord's responsibility to do that. I think one of the points that y'all had discussed with the judge earlier on was that they were going to stipulate that they controlled the area, that they were in complete, they had all the power in the world to do the light switch or not do the light switch installation. When something like that comes up, another hallmark of a good advocate is listening to the witness's answer, even if you don't expect it to come that way, and being able to connect the dots about what you're able to do with that new answer. Because I would think that would open the door for you to say, well, you installed a light switch later, you had the power to do that, you could have done that before, and then you would have gotten in this evidence and scored a little bit more points with us.
Ms. Jackson.
I think we saw two very talented trial attorneys here today. This was a very evenly matched round, and I've been judging for about 10 years because I'm older than the people who just spoke before me. Plaintiff's attorney, Rima, I thought that you were very, very good and that you're slow and deliberate and articulate in how you present yourself, which is really good for a trial attorney because you lay out your case very carefully, but you need a little bit of animation and variety to keep a jury's attention because juries get bored. So I would just suggest you change your animation and change it up a little bit to grab people's attention. That's something that defense counsel was really good at doing. She's very animated. She moves around a lot. So she really kept my attention. But Rima, I really want to compliment you on your cross-examination. You had an uncooperative witness there and you responded very calm, cool, and deliberate. I was really impressed with your cross-examination, so well done. And then Jenna, I thought your motion to eliminate, your response to that was really well argued, so really good job there. I really like your energy. Like I said, you really captured my attention. And then generally for both of you, I'm a fan of a very limited, not very detailed opening statement because it's just a roadmap and you don't want to oversell your case, like one of the other judges had said. And you as advocates in this competition and in others and as trial attorneys want to show your skills with your witnesses and where you're gathering evidence. So don't confine your time and your talent to opening statement. That's just a roadmap. Keep it simple. Save all that energy, in my opinion, for the trial of your actual case. So congratulations, you're both very talented.
Yeah. I would be scared of either of you.
Agreed.
If I found out you were the other side.
By the way, I'm a career prosecutor, so I spent my life in the courtroom. So
yeah,
that's my basis of my experience. Congratulations.
Yeah, y'all have gotten comments from very accomplished trial lawyers, not people that study this in law school, but people that do this every day. So take that for what it's worth, because I think it's very valuable. Rima, you know, the one thing I think that you could have really taken a chunk out of the defense was to ask, rhetorically or otherwise, how many staircases have you seen with no rails? Every place you go, you are put on notice that rails make stairs safe. And so the idea that she didn't know, or that they couldn't have known, or that there really wasn't any real danger is belied by every staircase you see, every place you go. So, I mean, I think you really had, you know, a way to kind of put that in a really strong way for you. And so I'm just throwing that out there as maybe something you can use. And then Jenna, you know, I have a visual picture of Ms. Gilmore smoking her cigarette out there at the base of the stairs, and then looking at her watch and going, oh, it's time to go to work. And she stubs out the cigarette and she goes up the stairs. And what does she see? A 4-foot wide door right in front of her. Now, she can go over it, or she can push it forward, or she can try and do her ballet move around it. Which is the worst choice? The one she chose. And I think if I get kind of these solid kind of visual images of what a person's choice is, I can then make a better judgment about what would be reasonable and what wouldn't be. So don't speak theoretically here. Make me live the way this case, the way that it was acted, that it actually happened. And then I think you can have faith that I'll make the right decision on it. Stay away from the theory. Stay away from the abstract, put me at the place and have faith that I'll make the right choice. But anyway, as I said, the main thing was I would have been scared of both of you or either of you if I had to try a case against you. Actually, I'd enjoy the battle. All these people that are your judges would have too. Thank you for working so hard on this. Is there anything that we could answer that maybe could give you some help or advice going forward? Or are you all ready to go get ready for the next one? All right. We're good to go. Everybody can sign off.
Good luck.
Yeah.
Thank you.
Good job. Good luck, you guys.
Thanks so much. Great job to you too, Rima, and good luck to you.